Someone make it make sense.
Probably a couple.
Hello, hello. We have a surprise live here. Welcome on in, everybody. Shout out to James, who's first here in the chat immediately after I created the live stream. Shout out to James for always being here and always being so supportive, and all the Squirrel crew as well. We are here to cover the other orders that have just come out on these motions here. Previously, we covered the order on the state's motion to eliminate with the text messages in 911 call. That was insanity. If you guys missed it, it's in the playlist, and I do have very specific timestamps for that already finished. Yeah, that was crazy. But today we are going to be doing the order on defendant's motion to strike the death penalty regarding autism spectrum disorder, and the order on the defendant's motion to eliminate for vague and undisclosed expert testimony. So we're going to start out with this one. Okay, so and I know that some of you guys had some questions about supporting case law and whatnot, so we will go through that and see. I'm sure that Judge Hippler will discuss, I'm assuming this is denied, right? But I'm sure he will discuss why he found the supporting case law offered by the defense to be insufficient in persuading him or mandating, if they had binding authority to strike it. Of course, we discussed this a little bit at the end of the last one on the difference between supporting or persuasive authority versus mandatory and binding authority, as in case law, right? So, okay, so. So I don't think we need to do much of the introduction here. Well, okay, let's read this part. So let me zoom in. Okay. He contends ASD is the functional equivalent of an intellectual disability, which is categorically recognized as a disqualifying exemption to the death penalty. Even if the court rejects a categorical approach, he argues the death penalty option should nevertheless be stricken in his case, given the intense media attention on the defendant's disability. In response, the state disputes that ASD is equivalent to an intellectual disability for purposes of a categorical exemption to the death penalty, and further notes that defendant has not shown a national consensus supporting such an exemption. As for defendant's individualized argument, the state contends that none of the defendant's concerns warrant striking the death penalty. While argument was heard, and the court took the matter under the advisement, the court finds striking the death penalty is not warranted. Again, I'm not really surprised here. And then the standard. So we have constitutional issues. Oh, that's way shorter than I expected it to be. That's what she said. Facts. During the course of this case, the defense team retained Dr. Richard Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of defendant and issue a report. As part of this evaluation, Dr. Orr interviewed defendant's immediate family members, and other relevant adults from defendant's childhood, including former teachers. She gathered information on the defendant's history, made behavioral observations, and administered cognitive tests. Based on her evaluation, Dr. Orr diagnosed the defendant with Autism Spectrum Disorder Level 1 without accompanying intellectual or language impairment. I think that this is going to be one of the things that is going to be a challenge here. Well, we already know he already said it's denied, right? But was a challenge, rather, for the defense because there's no intellectual or language impairment. I think the intellectual impairment would have been, it's more important here than the language impairment. But yeah, according to Dr. Orr, ASD is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social and behavioral features. It causes deficits in which affected individuals perceive and react to others and their environment, causing problems in social communication, interactions, repetitive behaviors, and narrow ranges of interest. And there's a footnote. I think it's just going to cite the report. Yep. And a lot of this we know, right? I'm not going to read all this. It's redundant. We know there's a wide range of symptoms. Pursuant to the DSM-5, there are two primary diagnostic criteria for ASD. The first criterion is persistent deficits in each of the following areas of social communication and interactions. So, and again, this we've read a lot of, right? We already know a lot of this, so I'm not going to read all of it if we've read it before. So we'll keep trotting along here. The severity of ASD is based on these two criteria. There are 3 levels of severity, which correlate to how much support is needed. Level 3, which is the most severe, requires very substantial report. Level 1, the least severe, requires merely support. And of course, he was diagnosed with level 1. Again, add that to the part here where it said, the diagnosis from Dr. Orr said that there was not intellectual impairment, right? So you have lack of intellectual impairment, and then you have the lowest level of support needed and the least severe level of ASD. As to the first criterion, Dr. Orr noted in the report that the defendant's family and peers reported that the defendant displayed atypicalities and difficulties in social settings dating back to early childhood. And again, we've read through all of this again. And at the time of his arrest, let me read this part. She notes that these difficulties played a role in his eventual termination of his funding for his graduate program. At the time of his arrest, he was pursuing a PhD in criminal justice and criminology at Washington State University. Footnote 4, defendant previously. Let me read footnote 3 here, actually. Sorry. At an early age, defendant's school psychologist recommended that he be evaluated for ADHD and Asperger's disorder. And we don't really know if he was evaluated or if he was evaluated and found to not have it or whatever. Or sorry, just kidding. Just kidding. Keep reading, Chelsea. He was clinically diagnosed with ADHD only. Okay. So, and I do recall that in the defense filing, them kind of saying there was like a misdiagnosis or whatever, because it was not very well understood at the time. So again, as a child, it was recommended that he be evaluated for ADHD and Asperger's, but they diagnosed him with ADHD. And again, the defense saying that that was a misdiagnosis, or not that he didn't have ADHD or whatever. I guess they're saying they should have also found the ASD, right? And then he's now they diagnosed him as an adult. Dr. Orr did. Okay, then footnote 4. So defendant previously received an associate's degree in liberal arts with a concentration in psychology, a bachelor's degree in forensic track psychology, and a master's degree in criminal justice. Defendant achieved a 4.0 GPA in his master's program. In her personal evaluation of defendant, Dr. Orr observed that defendant demonstrated some typical social behaviors. It's typical for ASD, right? So then he's noting these. We've already read these a lot. Or sorry, just kidding. Typical social behaviors that are normal, right? So, okay, there we go. Fairly consistent, though intense eye contact, polite demeanor, and social conventions such as shaking hands upon greeting. He engaged in conversation that was never overtly inappropriate. However, Dr. Orr also noted social behaviors consistent with that reported by others, such as a lack of fluidity in his verbal interactions, awkward comments. Footnote 5. By way of example, Dr. Orr noted that defendant commented that he, quote, had a lot of fun, end quote, completing a cognitive test. I mean, I don't find that to be very odd. I mean, some people enjoy doing stuff like that, right? But this doctor thought that was awkward, I guess. Or abrupt responses, inconsistent understanding or acknowledgement of humor, and occasional intense gaze. She noted that he had poor reciprocity of interaction, including very frequent refocus of conversation back to his own experiences or unusual responses to my sharing. That's a quote from her. So my being Dr. Orr. She also noted his lack of close friends and his poor insight into his role in relationships. Dr. Orr further observes deficits in defendant's nonverbal communication, noting poor integration of verbalizations and eye contact, limited use of descriptive gestures, restricted range of affect. Footnote 6. Dr. Orr noted defendant's smiling was inconsistent and occurred in unusual and incongruent contexts. She also noted he did not display tearfulness, anxiety, or anger. Dr. Orr observed that defendant was generally clearly articulated and his speech was appropriate in rate and volume, but overall monotone. His language was generally appropriate in content and form with an extensive vocabulary, but overly formal. Often over-inclusive and disorganized, and highly repetitive with frequent scripted phrases. Interesting. By way of example, Dr. Orr noted that defendant often used phrases, and these are quotes, objectively speaking, mind you, to be fair, and moral of the story. Interesting. So this is actually, we're getting more information here than we had in the other filings, right? That's why I'm like reading this, because he's including things that neither the defense or the state included in their filings here. So this is interesting. I find this especially interesting here, these certain phrases we're getting. The thing is, like, we've never heard this defendant speak, right? I haven't anyway. I don't know if people have been like looking for videos and social. I've not heard him speak. We know he's not made any public statements since the arrest. Of course, that's also a good thing. So this to me is like the first insight we've had as to, I guess, sorry, let me take it back. We did hear him speak on the traffic stop video and when he was pulled over. So I do take it. I forgot about that temporarily. Remembering it now. So we have heard him speak there, but that's a bit different. The context, right? It's to a law enforcement officer. So this would be more like in a regular conversation, I suppose. So it is interesting to have an idea as to like his regular manner of speaking, if you will. As to the second criterion, Dr. Orr found defendant exhibited all 4 of the scripted behaviors. He engaged in occasional subtle rocking of his upper torso while seated, and again, the scripted repetitive language. He appeared fixated on the routine or timing of breaks and procedures during the examination. He also demonstrated rigidity in his thinking, behavior, and preservative ideation. So wanting to know the results of his testing, was highly interested in circumscribed topics, such as forensic psychology, intellectual topics, and Murakami. What? I don't know what that is. Let me look that up. Oh, it's a Japanese writer. Okay. Oh, I know this. Okay, right. I was like, the name kind of rings a bell. I didn't realize it was when I saw this in the file, I didn't think author immediately. But now that I see, right, the Wind Up Bird Chronicle, Kafka on the Shore, Norwegian Wood. Right, I'm familiar. I've probably read one of these books. Anywho, okay, so that author. Okay. She noted he was also highly distracted by sounds or activity occurring around him, and frequently looked from side to side to monitor his periphery. As a result of being easily distracted, he needed instructions repeated to him. Now that does, again, we read the thing earlier about the ADHD. That does kind of sound like that. Welcome, David Bird. I don't believe I've seen you in the chat before, but welcome, welcome, welcome. Happy to see you here. Right, correct. Absolutely. After he was arrested, mainstream media, I think is what you mean by MSM, produced a parade of witnesses to odd behavior, which is explainable by this. Yeah, 100%, 100%. And, it's so funny because we see this in all these different cases, right? Like where somebody's arrested or charged with a crime, then there's, especially if it's high profile, there's gonna be a slew of people that come out and say, oh, we always thought he was weird, or we always thought she was whatever, so, and they can be saying that, right, without there being really any truth to that. But to the extent that there is any substance to that, right, obviously, yeah. I mean, and for anyone who's new here, right, I'm a violin teacher, and I have had a lot of experience working with students of all ages who are on the spectrum. And so I have a lot of personal experience too with the wide spectrum that is ASD. And, I'm very familiar with that as well. And so none of, everything that was described, to David's point is 100% on it's exactly what we're even reading here, right, in the Dr. Orr's findings. So, and again, that's part of why I really was hoping that this would be able to be discussed at least during jury voir dire. This is, of course, for the death penalties. We're talking the penalty phase, so it's completely different. But, in the other filings, there was mention from the defense of wanting to be able to bring up his diagnosis in the guilt phase, right? And one of the things I thought was the most important that they mentioned was, again, jury voir dire, because even if it doesn't come in at the actual trial, I think it's important because people having a familiarity with it, right? I mean, it was all denied, so it's a moot point anyway. But I think it should have been. I think it should have been allowed at least to be asked about in voir dire, because they're going to be judging him from the moment they walk in there, and he's going to be sitting there, right? And anyway, okay. Defendant's neuropsychological profile revealed a high. Sorry, I'm going to interrupt myself to say also too. It would be also important because you could have some people who have a bias if they don't understand ASD, right? So, for example, when they ask questions, as we know in voir dire, it's like, do you have any relation to law enforcement? Da, da, da. It's like, do you have any personal beliefs that pertain to people who are diagnosed with autism spectrum disorder. And they might say, yeah, I built up, right? If they have any negative bias surrounding that, then they should totally be, struck from the, from jury, struck for cause or what have you. So, and to the extent, and also I do think it'd be good for jurors that do have a familiarity with it, but don't have a bias, right? So anyway, okay. Defendant's neuropsychological profile revealed a high average intellect at baseline, and his full scale IQ score was 119, which is in the 90th percentile for his age. Cognitively, defendant showed strong verbal abilities, abstract reasoning, memory, concept formation, and reading skills. However, he displayed a weakness in executive functioning. And it's so funny. I was talking to Twiz earlier, and he mentioned executive functioning. And I was like, what is it? It sounds like a CEO. And I'd forgotten until I looked it up. And I'm like, oh my gosh, you're right. Executive functioning is there's so much overlap there with ADHD. So again, this is not surprising given that he was diagnosed with that as a kid. So he displayed weakness in executive functioning, such as planning, cognitive flexibility, impulse control, and organizational approach. He tended to perceive information in a piecemeal manner rather than look at the whole picture. Ultimately, Dr. Orr found defendant was clearly a neurodivergent individual, manifesting all the social and behavioral features of ASD. As noted, defendant was assigned a level 1 diagnosis without intellectual impairment, which is the least severe level. Dr. Eileen Ryan, a board-certified psychiatrist retained by the defense team, agreed with Dr. Orr's ASD diagnosis after conducting a comprehensive forensic psychiatric examination of the defendant. Of note, she observed that defendant is highly intellectual and has a factual understanding of the proceedings against him, the penalty he is facing, pleas, and the roles of the courtroom personnel, etc. Now, why that matters is because, so I will just say this. There's things that the defense left out of their filings. So, for example, in the defense filings, they cited case law about how one of the issues, right, is that for people that have these symptoms of ASD, although they couldn't cite case law specifically to ASD, but they cited other similar, what shall we call them, impairments or diagnoses, different types of diagnoses where people the defendants in the case law that they were citing, right, had challenges to where they couldn't understand the proceedings against them, right? And then here you have like a Sixth Amendment issue, right? If you can't understand your penalty, you can't assist in your own defense, things of that nature, right? The pleas, that was another thing that they mentioned, right? That he wouldn't be able to understand the nature of maybe a plea. And so they mentioned this directly, but the problem here that they had left out is that their own psychiatrist that they retained said that he does not have that issue. He is highly intelligent and has a factual understanding of the proceedings and the penalties facing, pleas, and the roles of the courtroom personnel. So therefore, if they bring in supporting case law that where somebody didn't have that ability, then that's not applicable here. It's not on point, right? She further noted there was no evidence of a formal thought disorder or thought disorganization. So then relying on the 5th, 6th, 8th, and 14th Amendments, the defendant seeks to have individuals diagnosed with ASD categorically exempt from the death penalty. Well, I don't know that that's what they're arguing. They want this individual to be exempt, but he contends a categorical exemption. Okay, well, maybe I'm wrong on that. That is okay, he contends a categorical exemption is warranted for individuals with ASD because they are insufficiently culpable and execution would not satisfy the retributive and deterrent purposes of capital punishment. Execution of individuals with ASD is contrary to the evolving standards of decency, and death sentences for individuals with ASD are inherently unreliable due to their inability to present meaningful mitigation evidence. And here it is, literally, this is what I was just explaining, right? This part, that they are unable to present meaningful mitigation evidence. Welcome, official. Welcome, Heather. Love to see you guys. Oh, Heather, were you gifted a membership? Oh, right. Your alt account was. I remember that now. Okay. Alternatively, he argues removal of the death penalty as a sentencing option in his case is warranted due to the impact his ASD will have on his ability to present a meaningful defense. Right. But particularly given the intense media attention on his disability. Now, that is a better argument for them considering their psychiatrist already found that he's not unable to assist in, understanding his defense and whatnot. So the media attention. Okay. So a categorical exemption from capital punishment for individuals with ASD is not warranted. The Eighth Amendment provides excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. We don't need to read all of this. At issue here is the first category. In Atkins, right? Atkins, they cited Atkins a lot. The court held the mentally, I'm not going to read this. I'm going to use the second one here. Intellectually disabled we'll use, must be categorically exempt from execution after finding that the cognitive and behavior deficiencies that drive an intellectual disability diagnosis negate the penological purposes served by the death penalty and give rise to a special risk that the death penalty will be wrongfully imposed. In addition, sorry, let me read footnote 7 here. While defendant cites the Idaho Constitution as a basis for his motion, he's not provided any argument or authority as to why the Idaho Constitution should apply any broader than similar provisions in the United States Constitution. So again, I forget who it was that was asking about the case law. Maybe it was Doug, but this is a great example of what we were talking about, where we were talking about, again, how to choose authority, right? And supporting case law and persuasive versus mandatory binding authority. But you know what is even worse is if you don't provide any argument or authority. So, okay, they didn't provide any, at least as it pertains to, yeah, wow, okay, well, there you go. So, okay, in addition, the court found that a categorical exemption was consistent with society's contemporary standards of decency. No court has ever found ASD to be a categorically death disqualifying diagnosis. However, defendant argues ASD is the functional equivalent of an intellectual disability, and therefore the rationale underpinning Atkins applies with equal force to individuals with ASD. And the thing is that this is what I was thinking about, right? Is like Atkins, I disagree with this. Like, y'all know how I feel about the death penalty. Well, most of you guys probably, if you're new here, maybe you don't. I am firmly against it for many, many reasons. But regardless, that being said, in assessing objectively the supporting case law to the defense's motion, I mean, it's a lot like with the IGG in a way, where there just really isn't any, right? And now, as we know, somebody has to be the first, and then you have precedent. Somebody has to be the first, right? But until then, you're going to be choosing case law that is the best you can do, right? In this case. So you're not going to have any mandatory binding authority. So you're going to have to go with persuasive, and you're going to have to find something that's hopefully on point. And the problem here is the best they could do is with Atkins now. And Atkins is not on point, in my opinion, because Atkins, again, was people that had, like, I'm sure it'll be mentioned in here. It's like an IQ under 70 or something along those lines. It's just not the same. Just not the same. So let me see what you guys are saying in the chat. What last chat was wild now? Hold on. Let me see what you're saying. PNW. I think you guys are talking about people I don't know. I'm just reading what you guys are saying. Yeah, I don't know. I'm not sure. Ooh. Right. Heather, we're all on the same page, because could you tell I was like going to make a joke, and then I'm like, it's just not appropriate because that's a real word. But like, could you tell the way I read it when I said penological that I was like, meh. That's hilarious. Welcome, Turquoise Kitten. Happy to see you again. Welcome, Just Beth. I don't know who you guys are talking about, but probably not, it seems like. You imagined that's fun. Oh, that's hilarious. What is penological? Oh my God, that's hilarious. I'm sure he would. I think he's asleep. That's hilarious. I love official adding the tools to his name. It's my favorite thing. Okay, so Atkins, right. Okay. Yeah, I mean, basically what I'm saying is it's a shame, right? It's a real shame because, again, I'm against the death penalty, but again, assessing the best they could do with the case law is not on their side at all for this, right? It's just not. He further argues that categorically excluding individuals with ASD from capital punishment is consistent with society's prevailing standards of decency. The state responds that a categorical exemption from the death penalty is only available under the law to those intellectual disabilities. Yep. And the definition of which ASD fails to satisfy. Sadly, I mean, again, I agree. I don't think that ASD would. Now, having said that, if you're at the third level, for example, I had a violin student in Boone who I'm sure was the highest level of ASD, and it was due to having a bunch of seizures as a baby. It was like a specific type of ASD. She did have intellectual and physical disabilities, like 100%, somebody with that type of ASD 100% would qualify under every standard. And not that hopefully she would never be here, right? This student that I'm referencing, but just saying it could be, right? But somebody with that level of ASD, I suppose, has yet to be facing the death penalty, which is why there's not any case law for it. So anyway, just saying that it is possible to have ASD with intellectual disabilities that 100% would satisfy because I've literally seen it. It further disputes that there is any national consensus supporting the defendant's claim. As a side note, this student who again also had physical disabilities can't grasp anything. Like she couldn't use her hands. Like she couldn't do a button or hold a pencil, or like her hands are basically like kind of like claws that are stuck like that. And part of the reason that she loved violin, and part of the reason they wanted her to learn, and she wanted to learn, but the reason her parents were really supportive was because they were hoping it would actually improve her dexterity in her hands. And we didn't have any goals going into it besides her just having something that she enjoyed. There wasn't like, okay, we want to be able to, we didn't know what would happen, right? But I'm really happy to say that after like, I think maybe 6 months of lessons or something, she was playing violin and was able to play violin. Like it was like an incredible moment. Like it really helped her. She was so happy, but also her hands, like it was amazing. So anyway, yeah, I agree with that, Heather. 100% agree with that. Heather saying there's far better reasons I could get them no DP if addressed correctly. Yep. Maybe we'll see some subsequent motions. I mean, they're not precluded to, that they can't file additional, I would be shocked if we didn't see additional motions, regarding the death penalty. Yeah, I'm not a fan of Hippler personally, for sure. That's interesting, Heather. Or was that something you were like born with, or was that you developed that over time? 100%. Yep. That's very true, official. Yep. It's a savant, right? If you guys look up savants are a subset of people with ASD, but there's like 1% in the world. They're considered to be like, it's like if you're genius level, like gifted in like certain areas. And it's a whole thing. Welcome, Echoes. Developed. Okay, yeah. So that's a little bit different. But yeah, I see what you're saying. I can't remember. How did you ever explain how you developed it? Not that you have to. I'm just curious. Was it for like typing a lot, maybe? Yeah, I waited tables. For many years, like through like college and stuff. But you know what? Taking down orders, I never had to do because I could always memorize them. Maybe like even up to like a 12 top, probably 14 top. Now, if I had like something larger than that, I maybe would need to write it down. But normally I was just able to memorize everything when they would give me their order. People would always get nervous, right? And be like, why aren't you writing this down? And I'm like, I don't need to. And they're like, yeah, right. Prove it. And I'm like, da 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 da. And I go around the table and even if they had a lot of mods and stuff, and they're like, what? And I'm like, yeah. Again, I attribute any abilities that I have as a human being to violin. So, okay. So the state is correct. First, intellectual impairment. Again, unfortunately, I agree. I do agree with this. A hallmark of an intellectual disability is not present in the diagnostic criteria of ASD, and no court has ever found the two to be equivalent. Second, the defendant has not presented any evidence of a national consensus as to whether the death penalty is a disproportionate punishment for individuals with ASD. So one, ASD is not equivalent to an intellectual disability for purposes of death penalty exception. Again, I have seen firsthand where it could be there. It could happen, but it hasn't happened yet. Capital punishment must be limited to those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes them, quote, the most deserving of execution, end quote. I'm not going to get on my soapbox about what I think about this. Well, we're just going to keep reading. In considering whether intellectually disabled persons are, quote, categorically less culpable than the average criminal, end quote, the Atkins court relied on clinical definitions of an intellectual disability offered by the American Association on, I'm not going to read that, and the American Psychiatric Association, footnote 8. Okay, that's not really all that important. Okay, both define the condition based on the presence of two criteria. 1, sub-average intellectual function, and 2, significant limitations in adaptive skills manifesting prior age 18. Based on this criteria, the court found that intellectually disabled were categorically less culpable for their crimes, noting clinical definitions of, and I'm not going to read that again, this word, require not only sub-average intellectual functioning, but also significant limitations in adaptive skills. Again, my student that I had back in would 100% qualify for all of this. So these people oftentimes frequently know the difference between right and wrong and are competent to stand trial, but because of their impairments, they have diminished capacities to understand and process information, communicate. And you can see where he's going with all this, because literally none of this was found by those who evaluated the defendant in this case. None of this applies. Literally none of this. And this is the case that the defense is relying on. There's no evidence that they are more likely to engage in criminal conduct than others, but there's abundant evidence that they often act on impulse. Okay, you guys can read that. All right. Based on these deficiencies, the court found 2 independent reasons to categorically exclude the intellectually disabled from the death penalty, both of which the court found were consistent with legislative consensus that I'm not going to read that, we'll say impaired, should be categorically, we'll say intellectually disabled rather, right? Should be categorically excluded from execution. First, the reduced culpability of the intellectually disabled undermined the twin justifications underpinning the death penalty, retribution and deterrence of the crimes. As to deterrence, the court reasoned that same cognitive and behavioral impairments that render mentally disabled offenders less culpable also render them less likely to appreciate the consequences of their conduct and control their behavior. Oh yeah, the stat. Yeah, that's crazy. Yeah, you said that was at a Thai restaurant, right, official? Yeah, 100%. I know. I'm telling you what, though, guys. Like from day one, when they came into court, and he was like, "Well, I don't want to start out with an untruth. I don't want to be here or whatever." You guys heard it. I was like, "Okay, okay." I mean, that was all it took for me. I was like, "I see what this is." Like, what? Even if you're thinking that, why would you say that? You're it's your job. Like that for me I was like, done. I see where this is going. Um, that's funny. Heather says, penological must be sort of something like a pen. Yeah, I think you meant penetrometer, maybe. It's all good. Oh man. Oops, hold on. Heather, you're about in the hearing. I think you maybe weren't there when I did that live stream, but we covered all this. I covered the hearing, and then we did all the things. I feel like I've given my thoughts. I mean, take like okay. In summary, the thing that was craziest of all of that was Heather was asking about what he said about Cy at that hearing. So the fact that there's you guys know how I feel about hypocrisy, or if you're new, just know that I have no tolerance for it, no tolerance for hypocrisy. So there was the hypocrisy of like, the defense is making these really, or sorry, not even the defense, Cy-Ray, right? According to Hippler, right? I'm paraphrasing, but basically what he was saying is these are really strong accusations to make. These are accusations that could get somebody disbarred, and like, how dare you say that without whatever it was. I don't even remember what it was just, he was just getting really upset. Like he was just saying that, right? But then he goes and says, literally makes the same type of allegations about Cy-Ray. Like he said, you can't just say things in this court. And I know you weren't here on the first day of since we started the hearings and but like, you can't just make these types of, anyway, what I'm saying is like, he made really strong accusations about Cy-Ray. But the difference being that Cy-Ray was available and he didn't give Cy-Ray a chance to say anything. I mean, it is, and the thing is instead of asking questions to Cy-Ray, who wrote the affidavit and could answer them, he was asking them to Ann Taylor, who literally is like, why are you asking Ann Taylor when the person who you need to be asking is there? I mean, I know why, it's a rhetorical question, right? But that was infuriating. Welcome back, Miss Pottage. Happy to see you again. Not how it applies. What are you referencing here, Heather? How it can apply. I'm not sure. Are you referencing the DP here? You might have been. I'm not sure. So yeah, but that was the thing that I was like, I mean, we really needed to hear from Cy-Ray, right? That's what we needed. Because he was asking these questions to Ann Taylor, who is not, it was Cy-Ray's affidavit, right? Like she can address what's in the motions, but they were talking about that affidavit specifically. And, it's true that the defense in their filings, they didn't address the 7 days. And, we talked about that, right? I think that was an oversight by the defense because the state snuck that in and it worked, unfortunately. Like they didn't mention the 7-day thing at all in the previous filings. And then they snuck that in. And I looked at the timing of it and the state's filing was like a couple days before the hearing. Again, if you go back to that live stream, you can see all of this, right? I'm just trying to remember what it was. It was like 2 days or something. And like the only explanation that I can perceive is that Ann Taylor didn't read all of it. I hate to say that. Because they changed their argument. Like the state's initial filing was the GLDC red herring, which is what I've been calling it. And then they switched it. And then in their last response, they switched it. They left that, they abandoned the GLDC and they switched it to the 7 days. And so had she thoroughly read that, she should have been prepared. Well, and so then you had the Cy-Ray affidavit, right? Had she thoroughly read it, she should have had that, been ready to argue that, and then also had Cy-Ray address it in the affidavit. But I think that Cy-Ray supplied that affidavit before. It was like a 1-day difference between the state's filing and then the affidavit. So anyway, either way, Ann Taylor should have been prepared to address the 7-day thing. And that was the thing, like that it was successful. Like the state actually, and it's funny because there's a moment where you can see Ashley Jennings's face. Like when Ann Taylor keeps saying that she didn't know about the 7-day thing until just now. She says that several times. The first time she says it, like I made the comment at the time of the hearing of like, holy shit, did she not read it? And then the camera, if you look at Ashley Jennings's face, she looks shocked. And it's like, oh man, like her face to me said, wait, did she not read it? Which is exactly what I was thinking. And then you see her and Bill like look at each other and they're like, what? Did she not? Like, if I had to imagine what they were thinking, I think what they were thinking was, did she not read it? So that was sort of, anyway, for probably better to just go back and watch that live stream because to get my full thoughts on that. And, we did all the things, but that's just my recollection. And so in any event, that was the problem, right? Was she couldn't address that. And and even if the 7 days is irrelevant to the FBI route, it's relevant to the hearing. That's what the problem, what things are in reality, unfortunately, don't matter nearly as much in terms of the case itself and the litigation of the case. What matters is what happens in court. So whether something is or is not that we know of, or that other whatever, right? The thing is if Ann Taylor doesn't argue that to Judge Hippler when he's asking her about it, then it doesn't matter, right? Like, that's the thing. She has to make that she had to make that argument, right? And she didn't make that argument. She couldn't say anything about the 7 days. She was like, really caught off guard, it seemed like to me. Really caught off guard. Oh, I see what you're saying, Heather. Right. I know, for sure. He really besmirched Cy 100% and didn't give him an opportunity to respond, which is wild. Yeah, the old switcheroo. Mm-hmm. Right, that's true. She did address that part, correct. But yeah, but he wanted her to address the 7 days and she couldn't really. And I understand her mom I'm not blaming anybody. I'm not, and I had heard that her mom had just passed. Yeah. I mean, the thing though is, right, like they could have had somebody else argue it, right? Like if she didn't have the opportunity to read that full motion, they could have had somebody else argue it, right? So, and the other thing is this, right? Again, I'll just say it again. What we know or what we say doesn't matter, unfortunately, right? It's up to his attorneys to make these arguments. And, you better believe that they're not going to put him in a position with ineffective assistance of counsel. I refuse to believe that he's not receiving the most zealous defense possible, right? I 100% believe that he is receiving such a zealous defense with highly capable attorneys that are turning over every stone. And if they had found, that's why I think the problem was maybe a lack of preparation for the 7-day thing, because if there's something they could have provided, they would provide it, right? If it exists and if it exists and it's applicable and it would refute it, why would they not, right? Why would they not? It doesn't make any sense to me why, when he's grilling her, why she wouldn't provide the thing, right? That's exactly it. Yep, they got to come ready with Hippler, and they know that, and they know that. They know he's going to be quick to deny. I mean, I guess in this case, actually, it's the opposite, right? Because it was the state's motion to grant it, so quick to grant that for the state, right? Or if it's the defense, quick to deny things for the defense a lot of times. So, and that you have to come in, and he's going to go straight to the point, right? And he's going to say, address this, right? Now, again, had he gone over to Cy Ray, who was available through Zoom or what have you, could have been different, but he refused to do that. So that's, and I was shocked when she said she was satisfied when he said, yeah, you can have a voir dire outside the presence of the jury. And she was like, that's fine. I was shocked. Were any of y'all shocked when she said that? Were any of y'all shocked when she said that? I was like, wow. Like, to me, that I don't know. It's like, if the jury doesn't hear about it, then like that's what you want. Like, I was just shocked. I was shocked when she said that. I was just shocked. Right. But confronting him with it outside the presence of the jury, right? I mean, what will that accomplish? Okay. I mean, I don't know. I just don't see why. Judge Hippler did not say, how sometimes these orders are reserved in part, right? A lot of times where he's saying that's reserved in part, it's reserved until something else happens at trial or until the time comes at trial. He granted the state's motion. He didn't reserve it. He didn't say, okay, we'll wait until the voir dire outside the presence of the jury and then we'll decide. And then maybe you can still bring this in, right? That didn't happen. So, I mean, why would you then not, you know what I mean? Like it's too late, baby. Now it's too late, like the song. Anyway, I think that's a song from the 60s, but you at the very least bring something so that he can, you can persuade him to not go ahead and grant the state's motion, but instead to reserve ruling in part until the time comes and she can voir dire Ballance, right? I don't know. It's just thoughts. Heather, I know all these things. I don't know that you're hearing what I'm saying, though. I mean, I totally understand. I understand it, but I don't know that you're hearing what I'm saying. Like, Heather, I understand you're upset, but we need to, I think that sometimes if we get too, I'm just saying for any person, if people get, sometimes if we get really emotional, right, it can impede our ability to stay logical in terms of like assessing things, if that makes sense, right? Because, there's plenty to be pissed off about, right? But again, it's like I'm looking at it from what happens in the courtroom and what will happen in the courtroom and, the strategy with that, God, you're right. I know, Heather. I know. Heather's in all caps mode. Tonka, why are you saying valid Daybell? I'm curious. Shout out to Tonka. Glad you're here. Welcome. For anyone I've missed in the chat, I'm sorry. It's harder when I'm reading documents. And I agree with David on that. Yep, he'll limit it to that one question. I mean, the way Hippler, the way Hippler said that about like, we'll allow you to voir dire him outside the presence of the jury, that was like, to me, the way he said it, it was like a consolation prize, guys. That's the best way I can put it. Is he said it like it was a consolation prize, like this isn't going to go anywhere. You're done, but here's your consolation prize. Get out of my face now. And that's why I was shocked when Anne was like, okay, I'll take the consolation prize. That was my interpretation. Oh, I see what you're saying. Okay, if the FBI supported the work MPD has claimed as their own, the feds would support their work. 100%. 100%. Yup. I 100% agree. I 100% agree with that, Tonka, for sure. Yeah, there's a big difference. There's a big difference in what went down with, yeah, and we know it was Ballance as well. And the other thing is this too, right? Like in cases where, like, take valid Daybell is a great example. But there's plenty of other cases, right, where they use the FBI, but the FBI is with them all through and through, right? And you compare that to small town cases, and I've talked about this before, like, but for example, Delphi, right, and Moscow, where it's completely different. It's a completely different thing. Like they have the FBI come in for very limited things, and then they kick them out, right? Because as we know, it's up to the local law enforcement to decide, right? And once they say, they just are trying to get around certain things or whatever, but the FBI is not really involved. You compare that to valid Daybell, or you compare it to like Casey Anthony, right? Where the FBI was working hand in hand with the local law enforcement. They weren't just using them to get around certain things or what have you. They were working together and were a huge part of the case. And like, for example, in Casey Anthony, like so many of the witnesses for the state are FBI. Like they were utilizing the resources properly, if you will, right? And supporting each other, right? Same with valid Daybell. Okay, so I'm going to keep reading. Okay. Second, the court found that the reduced capability of intellectually disabled offenders gave risk to an acceptable. Did you guys notice? I automatically auto-corrected this to rise, and then I was like, wait, it doesn't say rise, it says risk. And then I read risk, but definitely it was supposed to be rise, because look, it says gave risk to an unacceptable risk. Nope. It should have been rise. I should have gone my first instinct, rise. Gave rise to an unacceptable risk that the death penalty could not be reliably imposed. Namely, the court found that in the aggregate, intellectually disabled offenders faced a special risk of wrongful execution because they, 1, are more susceptible to false confessions, 2, less able to make a persuasive showing of mitigation in the face of prosecutorial evidence of one or more aggravating factors, 3, may be less able to give meaningful assistance to their counsel, 4, are typically poor witnesses, and 5, their demeanor may create an unwarranted impression or lack of remorse for their crimes. Now, that one is applicable, right? Further, the court found that reliance on intellectual disabilities as a mitigating factor can be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. Relying on the diagnostic criteria set forth in DSM-4, various publications in Dr. Orr's evaluative report, defendant argues that individuals, ASD himself included, exhibit similar adaptive impairments to those. Now, did he mean to say DSM-5? Why is he saying DSM-4? Right. And again, Atkins, I agree. Atkins does not apply. It's apple to oranges. And there he's going on about why Atkins is not, it's not on point. There's just no way around it, unfortunately. This is just more about Atkins. Further, even if adaptive deficits alone could give rise to a categorical exemption, defendant has presented no case law, right? That the adaptive deficits of ASD have the equivalent effect on culpability or on the ability to make a persuasive showing of mitigation, as does an intellectual disability. He dedicates a large portion of his briefing to describing how individuals with ASD, like those who are intellectually disabled, struggle to present meaningful mitigation evidence due to their adaptive deficits. He contends that and this is literally the point I was making earlier, where the findings by one of the psychiatrists who evaluated Bryan said that this doesn't apply to him. He contends they are less meaningfully able to assist counsel due to their social and communication deficits and their tendency to focus on specifics rather than the whole picture. And then again, the flat affect, all this, double-edged sword. However, to even be considered for a categorical exemption from death penalty based on these adaptive impairments alone, he would at a minimum have to demonstrate that, considered as a whole, individuals with ASD suffer from the same or similar impairments that render them more susceptible to false confessions and diminish their ability to assist in their defense. Indeed, it's on a spectrum. Some may suffer from adaptive deficiencies to a degree where it does interfere with the presentation of mitigation evidence, and some may not. Yeah. Further, the courts have considered whether to extend Atkins to mental health disorders similar to ASD have uniformly declined to do so. For example, fetal alcohol spectrum disorder, interesting, which is a group of conditions that occur in a person exposed to alcohol before birth, is characterized by many of the same behavioral. Interesting. Footnote 11. Oh, God. This is basically, I'm going to summarize this. This is basically what I've been saying the whole time, but he's putting it all in writing, right? That this defendant had a 4.0 GPA, he has an IQ of 119. All this is saying it's not the Atkins standard, right? Okay, now here's footnote 11 about fetal alcohol syndrome. It's not a clinical diagnosis like ASD. However, according to the CDC, the fetal alcohol syndrome includes these other behaviors that are similar, basically. So, Anne, when I've so far, Anne, referencing the Valadaybal case, be it in hearings or in filings, I don't even know that they've mentioned it out loud in court. No, maybe they have. She's used, it was where I've heard it and where I've read it, because you guys know I covered it, right? So I'm like, oh yeah. And of course, the other thing I will just say, before they even brought it up, like they being Bryan Kohberger's defense, I had used the Valadaybal case as an example in previous, like my previous coverage. I'd used it talking about the death penalty and all that. So then I'm really there for, if it's mentioned, I'm very much like, I notice it, right? But anyway, where I have seen or heard it in reference with this from his attorneys is only in the one with the motion to preclude the death penalty due to the disclosure. I have not, I don't recall. Let me know if I'm wrong. I don't recall. Now, having said that, I've not yet read this one, which is the order on, but again, that would be the judge. So that can't be it. So I've not heard or read them talk about validable except for in relation to the discovery and the disclosure and the motion to preclude the death penalty. Okay, so right, we've read. Okay, there's footnote 11. That's where we were. Reasoning that fetal alcohol syndrome cannot be medically equated to an intellectual disability, courts have found that the justifications for exempting individuals with intellectual disabilities from death penalty do not apply to individuals with fetal alcohol syndrome disorder. Okay. Likewise, courts, including the Idaho Supreme Court, have squarely refused to extend Atkins to severe mental illness, such as schizophrenia. Right. This was in one of the other filings. I think the state mentioned it. In some, the defendant has not demonstrated, nor has any court held, that persons with ASD have similar cognitive and behavioral deficiencies that result in an equivalent diminishment of culpability, ability to be deterred, and capacity to assist. I mean, yeah. And then here's the national consensus. This is going to go less far even. So this is just about societal awareness, right? Basically. And literally, I was just going to say, I don't think they had any supporting case law, and then keep reading, perhaps recognizing the lack of legislative acts in support of his argument, right? Defendant attempts to show a national consensus against executing individuals with ASD throughout a handful of court decisions, finding the diagnosis to be of evidentiary value, footnote 16. And here's the case law that they cited. And he's going to go on to say why it's not on point. Right, meow. None of these, however, are capital cases. Bam, there it is. There it is, people. None of these, however, are capital cases. He also cites to a recent media attention. And actually, before I keep reading, let me go down here and look at what they cited. So they cited, just to go through like what type of authority is it, right? So they cited, actually, I need to first find out what circuit. So Ada County is in the Ninth Circuit. All right. Excellent. Now you'll see why I asked that question. So when we were talking about mandatory binding authority and versus persuasive, remember what I said, guys. Mandatory binding authority is authority that is in the same jurisdiction and at a higher court level than whatever court level you're currently in. Right now, we're at the trial court level, so it's the lowest court level. So we're talking anything that is from the Idaho Court of Appeals, Idaho Supreme Court, or U.S. Supreme Court. That is mandatory binding authority for this court that we are in here now. Anything else is persuasive. Now, there's different levels of persuasive, right? So when we're talking federal case law, right? Again, U.S. Supreme Court is binding on everybody. So we're talking federal case law is going to be Court of Appeals. You want to find things that are in the same circuit. So that's why I just Googled what federal circuit is Ada County, and it's in the Ninth Circuit, which I figured because I saw this, and I was like, I saw this Ninth Circuit. I was like, I would imagine this is the circuit, right? It is. So your best chance with your persuasive authority is going to be from the same federal circuit, so federal court of appeals, as to where you're at on the state trial court level. Okay. And just to be clear, the way it works with these circuits is funny, right? So you can be in one state, but it can fall in multiple different circuits. For example, I'm in the circuit that I'm in, I think it's the Fifth Circuit, covers, I think, a portion of North Carolina and a portion of South Carolina. And the funny thing is that it covers, like, for example, where Murdoch is, right? The low country, we're in the same circuit, weirdly. Anyway, so, okay. So Ninth Circuit. All right. So Federal Court of Appeals. So again, persuasive authority. And then what else do they have here? Minnesota Court of Appeals. So this is less good for in terms of what's going to be persuasive, because this is from another state and it's from their Court of Appeals. That has no bearing, right? Other state case law from other states, when it's like state level, right? is, I mean, again, you can include it. It's persuasive, but how persuasive will it be? Now, the answer when it comes to this is, especially when none of them are on point even, right? None of them are capital cases. The answer is none. None persuasive. None persuasive. They're not on point. So we talked about that before, right? So that's the other thing. So you want to find your best case law possible, but then you also want it to be on point. So welcome, Donna. I haven't been reading the chat because I've just been talking about my things here. Not my things, I get really excited talking about this stuff, right, guys? But I'm happy to see you here. And then for anyone else I missed in the chat, hello. Couldn't agree more here. Now I'm taking a look to see what you guys are saying. Yeah. Yeah, the word, yep. There's a lot of salad coming in these Hippler orders here. Interesting, Tonka, same circuit. For anyone who doesn't know, Tonka joins us from Alaska. So love that you pointed that out. Thank you. The great example, right? So yeah, so these are not on point. So the amount of persuasiveness is nil, sadly. Okay. And unfortunately, the scroll friend, I believe it was Doug who was asking this question on the previous Kohberger live stream, isn't here right now, but I'm sure that he will enjoy watching this on, well, I would hope he'll watch this on Replay Crew, because this is thoroughly going to answer his question, probably way more thorough than he ever expected. But that's how I roll, right? I'm nothing if not thorough and squirrely. All right, none of these are capital cases. All right, he also cites your recent media attention on a Texas capital case against Robert Robertson. And I'd actually already heard of this case, an autistic man. This is the shaken baby syndrome. We talked about this before. Basically, none of these are helpful and they're not on point. Right. In sum, not only has, that's rough. Not only has defendant failed to show that ASD is equivalent to an intellectual disability for death penalty exemption purposes, he's not shown that there's a national consensus against subjecting individuals to ASD with capital punishment. Case-specific factors do not warrant defendant's exemption. So here, like the media attention, yeah. None of this is surprising. It's denied. Not surprised. But I agree with what Heather said earlier, which is they've got way better issues in terms of including, the death penalty. And I do expect to see other filings. Okay, moving right along, guys. So I've not read this yet, but apparently there's some crazy things in here. So this is my first look. So hold on. I'm getting a pop-up from StreamYard. Let me unshare, reshare. Can you guys hear me? Can you guys hear me? That's interesting, Tonka. Yeah, I mean, we've talked a lot about the death penalty states. I mean, there's not that many states that are like actively executing people a ton, but Idaho's one of them. By the way, after this, guys, we can, I can set it up. We can redirect into another stream if you guys want, and we have some options available. Options include watching the juror interviews for Lori Vallow. I have that ready to go. I can just set that up and see so the jurors speaking out, there's that, but there's also the Karen Reed for day 4. And in that one, I have a couple things that we're going to do in addition to, because it's limited testimony and whatnot. But what I do want to do is I want to do a couple things. I want to revisit some things from the hearing on day 1 that, as per usual, I caught on timestamps, but I missed when we were watching it live. And then also what I want to do is take a look at the week as a whole, because it's the end of the week, and what has the if you're on that jury, right, what has the Commonwealth, what would be your impressions as far as just impressions in general? But also I want to pull up specifically the verdict slips and the jury instructions and look at what the Commonwealth has to prove. And have they met any of that yet? And how close if you're on the jury, right? If you're on the jury and you're thinking about, again, they're going to have all that going back with them to deliberate. And they were read the jury instructions on day 1. But and if you're on that jury, how close is the Commonwealth moving the needle? Where would you be, right? And what has the Commonwealth shown to support their case? So I wanted to go through that stuff as well. So we have 2 options there. So start thinking about that and let me know if you guys have a preference or if you want to do anything. Balance's testimony. So you mean in Lori's case, because that is just audio only, or do you mean in Chad's case? I think the audio is better with Lori's trial. There's a lot of, I'm trying to remember, there's going to be a lot of overlap, right, between both of those for some of that testimony, but there might be some differences. I don't remember if there was like any significant difference in his testimony in terms of what he testified to between Lori in Idaho and then Chad. So that could be a factor. But are you guys wanting to do the one from Lori's trial? Lori or Chad, though? Now the only thing is I don't have a stream set up, but I could do it probably. Balance in general is fine with Heather. Okay. We can do that. I have to set it up though. Like in other words, I would have to I'd have to set up a stream and make a thumbnail and whatnot. So I would probably not be able to redirect you guys, but we could have it start like 5 minutes after this, basically. Hopefully you guys can find your way without the old portal. But we can do that. I know the only thing I will say is I know Twiz would want to watch that. I would think that's like Twiz territory. And I think Twiz is sleeping, but can we wake him up? We could maybe wake him up. He has told me, guys, I'll just say this since I think he's asleep right now. He has told me that like there's been times where he's like, how come he was like, oh, I was asleep and I missed this live stream. And I'm like, okay. And he's like, well, why didn't you wake me up? And I'm like, what do you mean? And he's like, call me, wake me up. And I'm like, you think that'll wake you up? He's like, yes. And I'm like, okay. So then I did what so then it's like, if I was going live, I would call him. Well, every time I've tried, it doesn't wake him up. So I just wanted to point that out, but who knows? Maybe it would work this time. Great question. I have no idea. If Lori and Chad are still in love, it's a great question. I mean, they're still married. I think Lori is still in love with Chad. I mean, we watched in the Discord last night, we watched her post-verdict interview, which we can't watch on YouTube because the Arizona true crime people, like they will take your stream down and whatnot. So we watched it in the Discord. It is very interesting. And the impression I get from her is she's totally still in love with Chad. That's funny, Heather. So, but I did want to mention that, like, to the extent that Twiz can't be there, would it be mean of us to do this without him? That's one thing to think about. Should we wait till we can have Twiz? I don't know. I feel like maybe we should, but I can try to wake him up. Okay. So, let me drink some water. Huh. That's funny, Heather. Okay. So the vague and undisclosed expert testimony. All right. Defendant moves to limit or exclude several types of experts disclosed by the state on the grounds that their disclosures are deficient in some regard. Footnote 1. And we're off with a footnote. Defendant's challenge to Riley Nolan's expert disclosures was addressed. Okay, we don't need to read this. We already did this. Been there, done that. The state responds it has complied with all discovery obligations and its disclosures are sufficient. It adds that several of the defendant's challenges are fodder for cross and not exclusion. I will agree that some of it is fodder for cross. But, I also love the expression fodder for cross. So I'll just go ahead and say that. I mean, sometimes things are not fodder for cross, and that is what the judge rules. And I'm like, for example, Judge Bev will rule that. And I'm like, no, I don't agree with that. But other times I do agree with that. But I do also just love the saying. Oral argument on the motion, we know. Okay, the court finds no basis to exclude or limit disclosed expert testimony at this time. But if a defendant believes an expert is testifying at trial outside the scope of his or her disclosure, well, of course they can. Why is he even including this? The court, he says he may object. Of course they can. outside the scope of disclosure is a really common objection. Why would you even do this? This is another consolation prize, guys. This is another consolation prize. This is making it seem like he's still being like reasonable, but this is like, it goes without saying. This is what you do. Dude, I'm not going to start goading. It's just too soon for the goading. Okay. Standard. A trial court's, okay, wait, this is literally what has been repeated in every single one of these. I'm not going to read it for the bazillionth time. Okay, analysis. Welcome back, Toes. Welcome back, Toes. Just make a song. Does YouTube send you some type of notice, Heather, when they restrict you? Like, how does that work? Is it just because you show you're like invisible in chats? Is that what goes on there? Okay, analysis. So the rule requires the state to provide, upon written request, a written summary of any or report of any testimony that they intend to introduce at trial that qualifies as expert witness. We don't need to fucking read this. All right, let's move on. What does Hippler's order confirm? That you have a potty mouth? I don't know. Failed to rise to this. What are you referencing there, David? Okay, footnote 2. Okay, we don't, whatever. Okay, so this is a forensic scientist with ISP. She is disclosed to testify in the state's case in chief. DNA, blood, She will explain what DNA is. That it may be present in biological material left on an item when handled, and that it is collected for preservation and sent elsewhere for testing. She's going to testify that her work in this case, detailed in Lab Report 25 and supporting field notes. That report discusses ISP's processing of the defendant's Pullman apartment in Washington State University office. She took pictures, presumptive test for the presence of blood. Her rebuttal testimony concerns ISP's crime scene investigation and procedures generally, and the ISP's forensics team's processing of the crime scene at 1122 King Road, including identifying areas that contained. Sorry, the reason I'm reading this really slowly, if it seems like I'm reading it slowly, is this. We're getting new information. Because remember, we don't know what all the defense experts are going to be doing, right? So, I mean, we know some things, but not all things. So her rebuttal testimony. What does this mean? They're preparing for rebuttal, as in a rebuttal case, right? Which we don't see in every trial. Speaking of that, side note, our next Murdoch episode will be in the state's rebuttal case. One of the trials where the state has a rebuttal case. It's not often that you have it. Of course, it's always an option, but it's not, you don't always have it. But remember, if it's a defense and they're saying they're going to rebut somebody's opinion, that means it's in their case in chief. So when you have it from the state, it's a different context. So when it says like this, right, her rebuttal testimony, this would be if they put on a rebuttal case in chief, right? Because it's like if she goes the first time and does all this shit, right, then the defense has their case in chief. Rebuttal means a rebuttal case, okay? So why am I mentioning all this? Well, there's a reason, and it's because what this means, this is giving me information in my brain that one of the defense experts is going to be, guess what, attacking the crime, not the crime, well, the investigation, the crime scene investigation, right? Which is so funny. Think along the lines of like the expert they wanted to bring in, Michael Easter for Karen Reed, and Bev was like, I've never heard of this, and I was like, I don't believe that. I've never heard of this such a thing. What? It's in like every trial. Anyway, they're going to have an expert who's going to criticize the investigation. So how many of you guys get really happy hearing that? Like that, they're going to have an expert come in and criticize the investigation and the processing of the crime scene. You guys, I'm excited. I'm excited. Okay, let me see what you guys are saying in the chat. That's funny. I know. I mean, I guess it would come by way of an email. I guess it could be like a notification on YouTube, right? I don't know. Yeah, I understand. Emails are so, they've gone the way of the dinosaur, I feel like, in most cases, but some people still really use email, which is funny. What something's given the state an advantage. I mean, I agree the state has. I'm not sure what you're referencing though, but yeah, I mean, Hippler. I might have missed something here. Yeah, I was still not sure what you're referencing here, David. Illustrate his standard by way of example, backtrack the state failed to rise to this. Are you referencing something specifically? Probably. It's more difficult, right? As you guys know, when I'm reading the things and then reading, I miss things in the chat when they come in. I try to, or try to not miss anyway. Okay. But who else is excited about this, right? From the defense. Okay. Defendant argues Ms. Ayers' case in chief disclosures did not provide any opinions she has about crime scene processing or about the DNA at issue in this case. Thus, he asked the court to limit her testimony to her qualifying background and her work in lab report 25. As to rebuttal disclosure, defendant argues that it again fails to provide any opinion about crime scene investigation procedures, and it does not clearly state what she did in processing 112 Duquesne Road and what her opinion is regarding that work. Defendant's challenges misapprehend the type of expert Ms. Ayers is. Much like law enforcement, Ms. Ayers is a hybrid/fact expert. Our hybrid fact/expert. Okay. This is annoying. God damn it. I'm not going to go. So here's the thing. The way that Hippler can get around some of the expert disclosures, there's a lot of rules that surround experts in criminal and civil trials, right? And they're different between criminal and civil trials, but there's different obligations that have to be met, right? When you're submitting someone as an expert. The way that Judge Hippler, or any judge for that matter, can get around that if they so choose is by this thing. They're not really an expert. I will just say this much, guys. Now, for Karen Reed, I didn't follow up pretrial for the first trial, as many of you guys might know. I avoided it like the plague until I heard opening statements. But ever since the first trial, I've been privy to cover literally everything, every hearing and every document. But what I will say is this: what I've not seen in my exposure with Karen Reed, right? And they have a lot of talk about expert. What I have not seen Judge Bev do is I've not seen Judge Bev do this thing, which is saying, well, they're not really an expert witness, they're a fact witness. I've not even seen that from Judge Bev. Have you guys? I'm curious. Like, did this happen pre-trial for the first trial and I missed it? But having said that, there's been a lot of new witnesses added for the second trial. And I mean, I just feel like if this was part of her discussion or part of the discussion, we would have seen it. I've not seen her do this, but we're seeing this from Judge Hippler saying, well, they're really a fact witness and therefore it's not expert opinion testimony. I've not seen Judge Bev do that. Have you guys? That's my question. Okay. You might be referencing something we haven't gotten to yet then. If you're talking, I haven't seen anything about data or tutorial, but I think maybe what you could be referencing potentially, David, maybe, is what I literally was just reading this part potentially about the fact versus expert thing. But yeah, let me know. Have you guys seen even like, but my point was going to be like, I've not seen Judge Bev even do this, which would be, if you're a judge and you do this, this is an excuse, right? This is a way for the state to be able to have someone offer expert opinion testimony when it suits the state. But then when it doesn't, then you just call them a fact witness, and then they don't have to they don't have to do all the things that you have to do with experts. Do you see what I mean? It's cheating is an understatement. Cheating is an understatement because there's a lot of rules that apply with experts, right? It's a way to get around it. Hybrid fact expert witness. I mean, I've not ever even heard of this. Like, while I understand how it could be a thing, it's either you're designating them as an expert or you're not. And like, especially when it pertains to someone who's going to be coming in as a rebuttal witness, it changes things entirely. Because if they're going to be a fact expert in the first time around and then an expert the second time around, something's off. It might, like, and I wonder if that's what they're going to try to do. I don't like that at all. But again, I've not even seen Judge Bev do this. Hippler's disclosure cautioning. Disclosure cautioning. What do you mean, Heather? Oh, I know what you're, okay, I see what you're saying. Okay. Right. Okay. I see what you're saying. Yeah, you mean it was at a hearing, right? What was it again? I don't remember. I think it was literally to the same issue though, wasn't it though? About some people are facts people. Yeah, exactly. She will be educating the jury on crime scene investigation procedures to provide foundation for her testimony. This testimony is factual in nature, despite the fact that it requires knowledge, skill, experience, and training. Consequently, the absence of opinions in her disclosure does not limit her ability. I mean, they don't have to, dude. What the fuck? Either you're offering them as an expert or you're not. I mean, as we know, it's a completely different animal, right? Now, there's benefits to offering them as an expert. Like, if the state wants her to be an expert, right? Well, then the jury, potentially, some jurors will give the experts more credibility, right? That is probably normal for jurors. If they have someone who's an expert, they come in, right? And you guys have seen it, right? They have all this, they go through the CV. It's to impress the jurors, so that the jurors will really give their testimony more weight, you know, if they're qualified as an expert. But not only that, experts can rely on hearsay. Experts are allowed to speculate in a way, right? They're allowed to use hypotheticals. They're allowed also to, they're exempt usually from the witness disclosure, like they can watch the other experts testify. They are allowed to opine on other people's opinions. They are allowed to also, you can lead them on direct examination. You can lead them. So there's a lot of, and that's just to name a few benefits and incentives, if you will, right? An incentive to wanting someone to be an expert if it's your witness, right? So I just don't understand this hybrid thing. It's a thing he's made up, I think. I just don't know. So in addition, her rebuttal disclosures replete with explanations about how and why the crime scene investigation was carried out. Footnote 3. For example, the disclosure discusses why the team focused on certain areas of the home as opposed to others, why they decided not to collect mattresses and bed frames. Yeah, I want to hear that. I want to hear that explanation, because why the fuck not? And why they swabbed and or applied amino black where they did. Okay, what I take away from this is that there's going to definitely be, I mean, and it makes sense, right? Things that they didn't apply amino. Oh my God, and he spelled it wrong. Typo. Amino black. And it probably should be capitalized, because I'm pretty sure it's like a brand name or whatever, or sorry, not a brand, a proprietary thing. Whatever. Clearly what we're going to have is we're going to have the defense saying, why didn't you test this area? Why didn't you test this area? Why didn't you test this area? But more so than that, why did you not collect the mattresses and bed frames? I mean, I shouldn't be surprised, but still so basic. Oh my God. Okay. Calm down. Keep reading. Just keep reading. Fuck. Her testimony will be allowed to disclose. Great. Great. Just great. Wonderful. Y'all. The way that I lost my mind, what was it, yesterday or whatever, reading the bit, and then the dude with the kitchen knife, I have to just say, I've read a lot of court documents. That is the craziest thing I have ever. And by crazy, I mean most shocking thing I have ever read as it pertains to like a fact about a case. That is maybe just in any category ever. Like, it is the craziest thing I have ever seen in a court filing. And I'm saying it that way because had we heard it said in a hearing, then I would be saying it's the craziest thing I've ever heard in a hearing. The fact that somebody did that, right? The fact, like, about HJ with the kitchen knife, I literally, for so many reasons, even just thinking about it again, now I'm like going to be buffering of like the layers of reasons why that makes no sense and is just so crazy. And I can't even believe that it's being said. Like, what are we in? One of those parody horror movies? Like, that's what it reminds me of. It's like, like the horror movie, like parodies. It reminds me of that. Anyway, okay. Whew. Moving right along. Balance. All right. Balance. He's disclosed to testify state's case in chief about his analysis of the cell phone records, as well as his own drive testing measurements to determine the use and general location of their cell phones. Accompanying his initial disclosure is a 30-page cast report, which discusses and maps the data he reviewed. Wait, let's see. That's not the best key for that. Maps, wait. I like anyone knows that song, but anyway. Love you like I love you, maps. There's a song called Maps. That's what I'm singing. Okay. And maps the data he reviewed and the methodology employed. His supplemental disclosure goes through each page of the CATS report to discuss its significance. He will also discuss topics pertaining to how cellular technology works. What is a cell phone? Particularly how cell towers operate and how cell phones connect to the towers, how cell phone usage data is reflected in call detail records, and how those records provided by AT&T for the target cell phones in this case were used to create cell site maps showing their general location before and after the homicide and their direction of travel. I'm collecting the number of words in my vocabulary that I read regularly in these documents for the different cases that I'm covering that automatically trigger a song. It's expanding. It's ever expanding. Yeah, and I've never seen Scary Movie, but I guess that's kind of what I'm picturing. Something, a parody, right? Or even a B movie, like a B movie horror movie. I love B movies. I mean, really everything about it already was that, but the dude grabbing the college kid grabbing a knife in the kitchen, I can't even. We've entered a new realm. All right. In challenging Agent Balance's case in chief disclosures, defendant provides the affidavit of his cell phone data expert, Mr. Cy Ray. Mr. Ray complains that he is unable to identify Agent Balance's methodology, which was described in the CAST report. Mr. Ray states that the CAST report omits data and or fails to mention how certain AT&T data was utilized in his analysis, namely handoff data and drive test mapping, and why some data was ignored. Footnote 5. Mr. Ray notes that Agent Balance failed to include an analysis of handoff data for defendant's cell phone between the hours of 2:30 and 3, that he did not include the mapping he relied upon to establish the defendant was near the crime scene on several occasions before the crime, and he failed to disclose how his drive testing works to a sufficient degree. He asserts that this omitted data and methodology is exculpatory, and without it, he cannot fairly analyze Agent Balance's work. According to the state, its disclosures sufficiently identify Agent Balance's opinions and the facts and data he relied upon, and defendant's concerns are fodder for cross-examination. And in fact, in Agent Balance's rebuttal disclosure, the state marches through, that's weird, each concern outlined by Mr. Ray, offering additional explanation about what Agent Balance considered, including the handoff data and why. Steve, I don't know what you're talking about, Heather. Oops. What are you talking about? Is that an actor? Although that would make sense if it was an actor, because then it would be Hollywood, maybe. Okay. Marches to reach concern outlined by Mr. Ray, offering additional explanation about what agent balance considered, including the handoff data and why. I had a thought and I lost it. Defendant, however, asserts the attempt of clarification in the rebuttal disclosure is insufficient, arguing there is no disclosure as to why he has omitted 95% of the relevant coverage maps for his drive testing, no analysis or mapping of the handoff data, and no documentation provided of the cast report's peer review process, footnote 6. There is no requirement under the rule that the state provide peer review documentation of an expert's report. Likewise, the rule does not require an expert to identify the data they did not rely upon or why they did not rely upon that data. That's true. That is true. Heather, did you answer my question? You're just laughing at me. Classic. However, the fact remains that the defendant has all the facts and data that Agent Ballance relied upon to form his opinions, which are expressed within his cast report, photo 7. I draft. Oh, Steve G. I have no idea. I have no idea what he says. And I'll be honest, like, the only time I ever hear people talking about, like, in terms of on a live stream, like sometimes people bring up Steve G in the chat and I just don't know what's going on. But like Kane was talking about him a little bit earlier on the live stream. I literally just tune it out because I just don't care what Steve G says personally. Angel, did you change your username? So he's saying this isn't Hollywood. Okay. That's a dumb saying. I'll just say that much. That's a dumbass saying. Like, obviously it's not Hollywood. Anyway, I'm assuming this is you, Angel. Twiz fetch the crayons. Yay. Is this? Oh no, that's a, I don't know what, I was just looking at your changed picture. I don't know. That's like an elven woman. I don't even know. Oh, I see what you're saying, Heather. Right. I see. Right. The irony. Okay. I'm putting 2 and 2 together. The irony that Steve G says it's not Hollywood, but like literally everything about this is like a B movie horror movie. Yeah. That's 100%. That is funny. Thank you for letting me know that he says that, Heather. It's me, Angel D. Okay. Gotcha. Just the whole switcheroo. What was your picture before? I don't even remember now. It's a changed picture, I believe. Oh, AI spooky. Cool. It looks a little bit, is there an elven? What is that the word I'm looking for? Elvish? Elven? Fuck. It's been too long since I've watched Lord of the Rings. That's what that proves right there. It's been way too long. Okay. Right. A draft of the cast report was disclosed to the defense in the early stages of this case. It was subsequently peer reviewed, and the final draft cast report was issued and disclosed in July of 2024. Okay. Initial disclosure. Oh, he's just citing this. Okay, fine. Right. We know where it came from. Wait. While his methodology may not be set forth with as much specificity as Mr. Ray would like, Rules 16 does not require that detailed methodology be provided. It merely requires opinions, facts, and data for those opinions and the witness's qualifications. To the extent defendant believes Agent Ballance omitted important data or is relying on insufficient data for his opinions as far as cross-examination and exclusion. Moreover, if an opinion is not reasonably set forth within the disclosure, it will not be allowed. Footnote 8. Well, this is literally just going to be the thing, like you can object because it's beyond the scope of disclosure, right? Is that what it's going to say? Oh, okay, let's read this. This is not what I expected. It's more detailed. Oh, right. It was I remember. Gotcha. For example, defendant complained that at the hearing that Agent Ballance analyzed handoff data for the 7 minutes prior to the phone powering off at 2:54 a.m. on November 13th, 2022. We can all quote Twiz here, certainly. Feel free. But did not provide an opinion about what his analysis showed. Thus, defendant wants to exclude any opinion as to what his analysis of the 7 minutes showed. However, as pointed out in Agent Balance's rebuttal disclosure, page 13 of the cast report sets forth the agent The data agent Ballance relied upon to opine that defendant's phone used a certain tower and sector at 2:47 a.m. southeast of his apartment and ceased communication with the network at 2:54. I'm going to read that again. Page 13 of the CAS report sets forth the data agent Ballance relied upon to opine that defendant's phone used a certain tower and sector at 2:47 a.m. southeast of his apartment and ceased communication with the network at 2:54. He also explains that the location of a device is best estimated by the initial cell site versus the handoff cell site. Okay, that's interesting information to have because we know that Ann Taylor and Cyree have talked about the handoffs a lot. So this sounds like a battle of the experts thing. He will be allowed to testify to these opinions. If defense believes agent Ballance strays beyond these opinions, he can. This is literally what I thought the footnote was going to say. I thought the footnote was going to say only this, which is the thing he said earlier, consolation thing, right? Where it's like, of course he can object, obviously, but literally that's at the very end of this footnote right here. This is literally the thing. It's so offensive, right? Like, of course they can object beyond the scope disclosure. Anyway, okay. Oh, the Barnharts. We deep dove them. Do you guys remember deep diving the Barnharts? Do you guys remember that? That was so funny. Y'all remember that? Some of you guys might have been here for that. We watched his like video and it started out with like how they met and like their honeymoon story. That was really funny. Anyway, the Barnharts. Okay. Right. Their user behavior and actions. They are disclosed to opine that the gaps in data on the two devices. Wait, hold on. They are disclosed to opine that the gaps in data on the two devices were abnormal. Okay. So here's the thing. This is interesting information. The two devices. What two devices? Hang on. Two devices. Like the iPad, maybe? I don't know. Anyway, this sounds to me like Celebrite. Okay, well, let me just read the footnote. Footnote 10. Oh, hold on. We need to read footnote 9. Their rebuttal disclosures state simply, so again, they would be called potentially as regular, like case in chief and rebuttal, intend to rebut the testimony. So now we're getting, so this here is new information. We knew of Josiah Roloff, but I don't think we knew of these people. So these are people that defense intends to call, in addition to like Cyree and Josiah Roloff, that are related to the cell phone. Carol Pendon and Kevin Pendon. How is it possible there's another set of married people that do this? It was weird enough that you have the Barnharts, but now you've got another married. I mean, I assume they're married. I guess they could be brother and sister. Well, we're going to have to deep dive them as well. Very odd, this whole married couple expert thing. I'm just, what? Carol and Kevin. Oh, Jesus Christ. Mind blown. Mind blown. Is this on purpose? Is this on purpose because the state's bringing in a married couple? What is happening? The Barnharts and the what is going on? Is this like, what's those stupid dating shows, right? Where it's like they have them do things or like this is so weird. I've never in any trial even seen it where there's any people that are married that come in as experts, whether it's in the same field or different, like what? How is there two sets of them? I'm blown away. What is happening? Yeah, like The Bachelor. Like, I don't even know. Like, was there some sort of show where it's like, if you're an expert witness and you're single, come here and then meet your husband or wife? Like, I don't even know. Exactly. This is just very weird. How? And they all do digital forensics. And they're a married couple. What? I just had to verify it because I couldn't believe that I was seeing this after the Barnharts. We're not going to learn more. We got enough now, I think. Jesus. What? Okay. Another married couple. I literally never seen this in a trial. Now we have two of them. I'm blown away. Poor Josiah Roloff. Okay, here's what we know. Josiah Roloff, he needs to go to the same show. He needs to sign up for the same program or the same show where the PENDENS and the Barnharts met because he's not found his twin flame, Heather. He's not found his twin flame yet. Because we need to see a trial where then it's the roll-offs, plural. Fucking hell. All right. Defendant is not challenging these. Footnote 10. Specifically, their report explains that the gaps in the data may be consistent with cleaning up or using anti-forensic methods to clear evidence. Oh, is this the cleanup thing that you guys were all talking about? Hold on. The gaps in data may be consistent with cleaning up. So the way I interpret this is not cleaning up like with a broom and a mop. I interpret this as cleaning up like deleting shit on the cell phone. Or using anti-forensic methods to clear evidence. Anti-forensic methods. Like what, though? What are they talking about? What are they talking about? Like, this sounds like not just hitting a delete button. Josiah needs a twin flame. Exactly. That's right. He does. We need to see the roll-offs. Let me keep reading, and maybe there's more here. Okay. The gaps in data were abnormal. Two devices, though. It's just that this thing looks like it's not just simply like, you know, like we see it like, oh, someone deleted a text message, or oh, somebody's phone was off, or whatever. They put it on airplane mode, whatever the case may be in different trials, right? This looks different than that. The gaps in data they're referencing here. Wait, hold on. Whose report? I've just confused the fuck out of myself now, because now we start talking about the dating show. Which couple is talking about this now? Because there's all these different fucking couples. Where did footnote 10 go? Okay, so this is from the Barnharts. So the state's married couple experts. Oh my God. The state's married couple experts, the Barnharts, are going to testify to this. So this is what I'm saying is like, this is different than what we usually see, I think. This is what it looks like to me. Cleaning up or using anti-forensic methods to clear evidence. Like giving something a virus. I have no idea, but this looks different than your standard fare. That's a good point. Maybe. Now, having said that would be adding. This looks like taking away, right? That's a good guess. I initially, yeah, but that would, you know, the best way to do that would be to put your phone. Like I've always said, I'm not trying to help people criminal better, right? Or criminal at all. Don't crime. But like, if you're trying to like give yourself an alibi, right? Take your phone and put it somewhere else. Actually, somebody in the school chat had an even better idea. They were like, take your phone and put it with somebody who like put it in a moving vehicle or something like that. Like give it to somebody who, you know, like if you've got a friend who's going to go run errands and like just take your phone and like hide it in their car and like, you know what I mean? Like basically keep your phone on, keep it on. Don't do anything to it, right? Just take it and have it go somewhere else entirely. You know what I mean? And then retrieve it. And then you're out, then you're set. You're all set, right? As long as you're not caught on camera or there's no eyewitnesses and other things, no DNA, you know, whatever. But as far as the phone is concerned, right? But anyway, this looks like getting rid of things, maybe cleaning it up. Okay. And it says 2 devices, right? Which is another, that's a new one. That's a new thing to learn. Tape it to your, exactly. P Fox, welcome back again. Tape it to your Roomba. Yep. Yeah, right. Yeah, you could even leave it at home, but like tape it to your Roomba. 100%. Have you guys watched the show Parks and Rec and where they have DJ Roomba? Oh my God, DJ Roomba is my favorite thing ever. Love DJ Roomba. Shout out to DJ Roomba, by the way. I'm going to have to call Twiz here in a minute because we're going to have to make a decision here. if we're going to do that live stream without him, or like with him or without him if he can't wake up. Because we got options here, guys. For anyone who didn't hear, the options are after this we can do, I initially had said we can either do watching the Lori Vallow juror speaking out, or we can do the Karen Reed day 4 with all the other Karen Reed stuff that I was going to do. Or what was suggested in the chat from Tonka and Heather, or requested, was watching Nick Balance's testimony from Idaho, Vallow Daybell. But I was like thinking then, I was like, well, but should we do that without Twiz though? Because I feel like Twiz would want to be there. And so I will try to wake him up, but if he doesn't wake up, do we want to do it or not? That's the real question. Do we want to go with another option? Because I feel like he wouldn't want to miss it. I guess he could watch it on replay. I don't even remember who Jack D is, so I don't think I can weigh in on that. Was that Kaylee's boyfriend? I have no idea. I don't know anything about that, to be honest. And I've not seen anything about that, unless it's on another page. I mean, I'm on page 5. Maybe it's on another page. Keep reading. Okay. Okay, we were here at footnote 10. All right, let's keep going. Attached to their disclosures is a report jointly authored by the Barnharts. Okay, fine. Defendant argues that the disclosures indicate they will testify to habit evidence, which he complains is not explained and not accompanied by any opinions. Defendant's challenge is not confusing. Nowhere do the disclosures or the report indicate that Barnharts will testify about habit evidence. Okay, interesting. So he's saying he's agreeing with the defense here. Rather, the disclosures state they will testify to their findings pertaining to the defendant's activities on his PC and cell phone. Okay, so those are the two devices then, I guess, his computer and cell phone, for a period of time before and after the homicides, and why the gaps in... Oh, so it looks like he's siding with the defense, but he's really not. He's saying that they described habit evidence without using the word. That's what he's saying. And why the gaps in data over that time period are abnormal. The Barnhart's opinions regarding these topics are fully set forth in their joint report, their joint dating married couple honeymoon report. For example, they observed gaps in the defendant's school PC that may be consistent with, okay, cleaning up or using anti-forensic methods to clear evidence. Among the gaps found were information. Among the gaps found were in the PC's event logs. His school computer, though? Why would anybody, what would he be doing? Hold on, what would he be doing with the school computer, though? What is the state alleging that he'd be doing? Right, is my point, right? The school PC. Like, what the fuck? The dumbest thing for anyone to ever do, right? Like, fucking hell. What? Among the gaps found were in the PC's event logs and system resource usage monitoring, which the Barnharts opined was abnormal given the school was in session. Wow. Likewise, they located gaps in the PC's Chrome history during dates when downloads occurred on the system, indicating the user was private browsing or clean browsing history. Fine. That doesn't mean anything, though. That's like, here's the thing. If you're going to say that somebody's using some fancy forensic shit to do this crazy thing that's like super high level, but like also they're just deleting their Chrome history, come on. You can't be both a high level super criminal and like a dumb person at the same time. For example, hypothetically, if you were to like kill someone to death with a certain knife, or 4 people or whatever, and then literally right after go and be like on Amazon, okay, let me find a replacement. Like, who would do that? Anyway, okay. Together, the Barnhart's disclosures and joint report set forth all that is required, and there's no basis to exclude or limit their testimony. Oh. Okay. Let me see what was going on with this person, Jack person. Twiz does sleep. Twiz does sleep. He does sleep. He sleeps. He sleeps. Did anyone let me know what the thing is with the Jack D? Is that coming up in this document or what? Because after we finish this, we've read all the documents that exist here. We're up to speed. This is the last one. Because I don't think the Jack person was mentioned or included in any of these filings about the cell phone activity. Anyway, I could be wrong, but I don't remember it. It would be J. If they used initials, it would be JD. I don't remember that. Okay. Michael Douglas, forensic accountant for the FBI, and is disclosed to testify to financial transaction data for the defendant, the 4 victims, and the other roommates. Financial data, ATM withdrawals. Analysis of the defendant's spending habits. I don't know how that matters here, but he's intended as a fact witness. For example, the disclosure notes defendant only conducted ATM withdrawals on or and after the date of the homicide and ceased using his debit card after November 10th. Whereas prior to November 10th, he had regularly used his debit card. I have a question. Common sense question, people. How the hell are you withdrawing cash from an ATM without using your debit card? Look, the disclosure notes the defendant only conducted ATM withdrawals on or after the date of the homicide. On or after. But now it says that he ceased using his debit card after November 10th. That's before the murders, right? Whereas prior to November 10th, he regularly used it. How? How are you then? What? How are you? Oh, thank you, Toes. You can tap your phone on some ATMs. Okay, really interesting. I haven't been to an ATM in years because I never use cash. Okay, that would kind of make sense if they're trying to say he was not using the debit card anymore because he was just going to be using cash maybe to buy stuff. I guess that's what they're saying. Thank you for that. I had no idea. Thank you so much, Toes, for that. There's no indication he will attempt to opine about the reasons for the spending changes, just that they occurred. Footnote 12. Without more, the court has concerns about the relevance of this testimony. Yeah, literally, I was saying that, but the defendant has not challenged it on this basis yet. Okay. Thus, there's no basis for excluding or limiting his testimony based upon the disclosure concerns. Okay, Shane. Now we're on to the Amazon. Mr. Cox is a litigation and regulatory manager for Amazon. His initial disclosure states Mr. Cox will testify to the content of documents produced by Amazon to law enforcement pertaining to an Amazon account associated with the defendant. The documents include the order history between, we know all this, right? The documents are referenced by date number, Bates number. They're saying again, so that he should not be able to offer any opinion because none are expressed in his disclosures. Footnote 14. Defendant also asserts in his motion that Mr. Cox's testimony should not be allowed because, according to the defense expert David Howell, far more information must be reviewed in order to attribute specific activity. Yeah, what I've been saying this whole time, right? It's a household account. Specific activity to a specific person or otherwise render an opinion about user behavior with forensic certainty. This argument was addressed and rejected by the court in its order, right? Will not be reiterated here. Yeah, I'm surprised that the defense hasn't challenged it on relevance yet. That's interesting. Well, I'm glad he pointed that out, though. That's funny. Now, what I will say is this, though. If you do lose your bank card, right, what do you do? What do you guys do if you lose your bank card or your credit card or anything like that? What do you do? Let me know what you guys do if that's happened to you or what you would do. Okay. Where was I? Okay, yeah, that footnote. Again, Mr. Cox is a fact witness and will not be offering opinions on the documents apart from explaining what the document, should be documents plural, show as outlined in his disclosures. There's no basis for exclusion. Okay, Darren Gilbertson. right? But what do you do? What do you do? What do you do? Let's say you lose your debit card or credit card or whatever. What's the first thing you do? Darren Gilbertson, defendant disclosed expert opinions from Brent Turvey that more than one assailant, Brent Turvey, sorry, was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts that one, there's direct and indirect evidence that attempts were made by the suspects to clean up the crime scene. Oh, maybe this is the cleaning up that was mentioned. There was much talk about cleaning things, and I thought maybe it was referenced of the other thing, but maybe it's this. Evidence that the attempts were made by the suspects to clean up the crime scene after the homicides. Interesting, which would have taken far longer than the time interval alleged by the state. And two, there were multiple weapons used against. Oh, and multiple weapons. Interesting. Kaylee, huh? Oh, and if they were okay, that's interesting. So if they can prove, okay, if the defense can show with an expert that they could have been any two people, right, were killed at the same time, especially if they're in different rooms, then that definitely would be like, yeah, it had to be more than one person. But this is not what this is different. They're saying multiple weapons. I mean, they could still say that, right? But the multiple weapons used. Well, I guess they're not saying that. What are they saying? Let me read it again. That it would have taken longer than the time that was alleged, right? There were multiple weapons used against Haley, Xana, and Ethan. Sorry. There were multiple weapons used against Kaylee Gonsalves. Specifically, just that one person, just Kaylee, multiple weapons, and Xana and Ethan appear to be attacked at the same time. Now, the trouble there is that, I mean, you can see where that's going to go, right? If they're that, we know that they were in the same, they were near each other, right? So anyway, I just feel like that's going to be about all the experts on that one. Like what I was going to say is if they were going to be able to say like, oh, there's evidence that maybe Ethan and Maddie were attacked at the same time, that would be different, right? Through his other expert, Rachel Orr, defendant has submitted evidence that he suffers from developmental coordination disorder, which also results in deficits in fine motor dexterity and visual motor function. His attorneys have argued in other motions that these deficits render it not possible for Mr. Kohberger to have acted with speed and coordination required to commit crimes in the time frame alleged by the state. But those motions were denied, so it doesn't matter. It doesn't matter. It's irrelevant. However, this has not been disclosed in opinion of any defendant's experts. He denied that shit, so it doesn't matter. Yeah, so I was going to say, yeah, so thanks, guys. Report it to the bank, call and cancel. Exactly. So I was just going to say, in the event that anybody, including Bryan, if they lose their card, right, then the defense could bring in evidence that they called the bank to cancel it, right? Or whatever. Like there would be record of that. There would be very obvious, easy to get record of that. And they would totally bring that in to the extent that the state wants to suggest there's anything funny about the card, right? They would be like, well, he lost it and then he got it replaced. So, oh, that's interesting. PFOX first time ever. I've had to do it. Actually, I don't think I've ever lost a debit card. I have had to have it canceled because I had somebody somehow got in there and was buying shit like fraud, like crazy, right? Like you never, like I didn't even know it was possible, but like there was a charge on my card for like $900 or something like that from like some site I'd never been to. And I was like, whoa. So I had to cancel it, but I don't think I've ever lost one though. Different weapons does not equate to happening simultaneously. Right. Yeah. I just think it's just interesting that it's different weapons on only one of the victims from the way it was worded here by the judge. It looks like it was just one of the victims the defense is saying had separate weapons used on, but not the others, which is interesting. In rebuttal, the state disclosed Detective Darren Gilbertson, a lead investigator for ISP in this case. The disclosure indicates he will testify that he and other investigators conducted timed runs at 112 King Road to gain an understanding of the approximate time frame needed to have carried out the homicides. A report of the timed runs is attached to his disclosure. It was performed to determine if one person could carry out the homicides. His opinion will be that, depending on the suspect's pace and route, he could have carried out the crimes in approximately 2 to 4 minutes. What? Huh? Come again? That's what she said? No. That's hilarious. No juror on this planet's going to buy that shit. No juror is going to buy that shit. I don't care if you're a Navy SEAL, an FBI, CIA. I don't care who you are. Not possible. No juror is going to believe that shit. No one. No one. Absolutely no one. Nope. If you had 4 people that were all unconscious, that were all lying next to each other, like on the floor, and you're already in the room, okay, fine. Obviously, that's not happening in anything ever. It's a hypothetical of how could you make that happen. Like, this is just dumb. It's dumb. All of them being at the same time. I'm not sure what you mean, Heather. I mean, yeah, never mind 13 minutes. I mean, this is saying 2 to 4 minutes. This is saying 2 to 4 minutes from the state's person. 2 to 4 minutes. And remember, they're going to be relying on the dollhouse to give that opinion, by the way, guys. They're going to be relying on that dollhouse, guarantee you. Defendant argues Detective Gilbertson's testimony should be excluded because, 1, the state has failed to disclose how Detective Gilbertson is an expert in timed runs. Remember how I made the joke before, for anyone who missed it? I made the joke about this because in the other filings from the state, the way they explained this, it was like, I remember how I said, like, it said test runs plural. And I was like, wait, how many people did they have to kill? Did the government have to kill in order to test this out? Because they would have to kill 4 people every time. And it says runs plural. So I was making the joke, like, that means law enforcement killed at least 8 people to do this, right? Okay. The relevance is minimal. 3, important data. For example, recordings, photographs, and notes of the experiment was not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, defendant claims that Detective Gilbertson was already familiar with the house when he did the experiment. Okay. Additionally, the house has been vacated. Yeah, that matters. Defendant also notes that the house has been torn down, so he's not able to conduct his own tests. While Detective Gilbertson's opinions are relevant, whether they're relevant will depend on what Mr. Turvey, sorry, I can't say that normally. I don't know what's wrong with me. Every time I've read that, which is twice now, I've said it weirdly. And Dr. Orr opined to at trial, footnote 16. The court has indicated in a separate order that there's no foundation at this point for the assertion about, right, we already know. That's why I said that was moved. Okay. While Dr. Turvey does not specifically state in his report that one assailant could not have accomplished the murders in the short time frame alleged by the state, he infers as much through his opinion that there was evidence of cleanup efforts at the crime scene, which would have taken a significantly longer period of time. Further, while Dr. Orr's report does not opine as to what deficits in fine motor, I'm not even bothered reading this because, like, literally, the fine motor dexterity thing is not going to be coming in because it was denied. So, further, given Detective Gilbertson's role as the lead detective for ISP in the investigation, he is well qualified to offer his opinion on suspected movement throughout a crime scene. In addition, there does not appear to be a disclosure violation due to the lack of underlying data. It was a simple experiment consisting of timing Detective Gilbertson moving through the house at a slower speed and a faster speed. Oh, God. His routes were described as well as his pauses to simulate the number of stab wounds each autopsy showed. Oh, God. I hope they filmed this. They should have. Did they film this? They should have filmed this. Because I want to watch it because it's going to be hilarious. Imagine this, right? This Detective Gilbert. I hope we see this at trial. I want to see this. This is going to be, speaking of the B movie, this is B movie material, right? When you can't afford a dummy or a mannequin or even a knife. So you have to mime the whole thing. Oh my God. I hope we get to see this. This will make my life. Wait, never mind. It does not appear there are any photographs or recording or any other data described therein. What? Unless they're saying for something else. Hold on. It was a simple experiment. That doesn't sound like it's a very good one. So he's saying there's not any photographs or recording. You've got to be kidding me. Well, this is useless. This is going to be a laughing. He will be the laughing stock of this trial, one of them, because here's what it's going to be. You know what this is like? This is like in Murdoch on the state's rebuttal, where the dude threw the phone around in his office, and they're like, "So you just threw your phone around the office?" Yep. Did you have anyone videoing it? Nope. Did you have anyone there watching it? Nope. Did you do anything? Was there anything that made it anything scientific? Nope. So you just threw your phone around the office and just wrote down a number. Yep. That basically, I'm paraphrasing, but that's pretty on point. That's what this is. There's no photographs or recording or any other data. So how do we even know that it even took whatever time he says it is? This is insane. It's like, so you just ran around the house at 2 different speeds and then said how long it took, and we're just supposed to believe that it took this long? What? It was dumb enough already before. This can't be real. How are you supposed to prove how long it took if you didn't have a video of it being timed? Oh dear. Oh dear. Yeah, I mean, agreed, but the test is garbage. We're not even there to adrenaline and all the other resistance. We're not there. We're not there at all. We're not even, don't even worry about the actual. Let me read this again, guys. In addition, there does not appear to be a disclosure violation due to the lack of underlying data. There is no underlying data. That's what we've learned. It was a simple experiment. A simple experiment. It's not even an experiment because you're not testing it against anything. There's no control. There's no nothing. It's not even an experiment. Wow. Consisting of timing, Detective Gilbertson moving through the house at a slower speed and a faster speed. What does that even mean? Like, how fast does he move? Like, literally, you can't, there's no point in even asking these questions. This isn't real. Think about this if this was like a regular thing. Like, what? I mean, how fit is that? Dude, I'm not even bother. Not even bother. This isn't real. Moving through the house at a slower speed and faster speed. Yep, that's what this is. His routes were described, as well as his pauses, to simulate the number of stab wounds each autopsy showed. It does not appear there are any photographs or recording or any other data already described. That's it. Okay, I just don't even. Guys, like, what? So you're just telling this jury this is how long it took you? We don't have anything? That's before you even get to all the other nonsense of like, wow. This is just on a different level of anything. This is worse than the dude throwing his phone around. This is worse than corner armpits. This is the worst thing I've ever seen in my life. I don't even know what to say, guys. Like, this entire thing from the state saying, like, okay, you guys, isn't it a big deal for the state to try to prove that one person could have done this? Think about it, right? Like, what is the first thing that people said? Even when the window of time was bigger, it's gotten much smaller. Because now they're saying 2 to 4 minutes. It was a lot bigger. But even when it was bigger, right, the question that everybody had was, how could one person do this, right? Now the window is 2 to 4 minutes. And the question that every person on jury is going to be, how can multiple people do it in 2 to 4 minutes? How, really? And the answer that the state is going to offer is going to be this dude who didn't record any data. It was a simple experiment. And there's no pictures or photographs or proof of anything. And it's just him running around. And he's going to just talk about running around at different speeds. And that's how they're going to say it was possible in 2 to 4 minutes. You've got to be kidding me. You guys. This is like potentially, if you're a juror and you come in and you hear that this was done in 2 to 4 minutes and it would had to have been done in 2 to 4 minutes, this is the biggest issue, I guarantee you, for a juror. I don't care what you show them. If you tell them it had to be done in 2 to 4 minutes by one person, that is going to be the thing that they're focused on. Is that possible? And this is what you're going to offer to that? You've got to be kidding. This, for me, I think we all can be on the same page here, guys, right? That if the likelihood of a conviction in this case, because we know how it is with jurors, with the DNA, right? The likelihood of a conviction is high, right? Given what we know. I have to tell you guys that right here, this one thing has completely changed my opinion of that. I'm not kidding. If indeed there's like literally nothing to even corroborate this, and they have nothing else to prove that it's possible in 2 to 4 minutes, this is it. Like, I think it's over. Like, what? Like, I'm saying it's over for a regular juror. They have to prove it's possible in 2 to 4 minutes. They have to, by one person. Or what are we doing? Right. This is we've moved on from a fair-minded juror or a rational person. We've moved on to take any juror anywhere with any level of brains and in any, like, literally no juror is like, you see what I mean? We've moved on. We've moved on from, like, dude, take any jury of any people. I don't even care what level of bias really at this point. Like, this is, no jury's going to buy this. Like, if you can't, my mind is blown. My mind is blown. Is this it? Like, this is it? That's what she said? I'm just like, I mean, right? This has been the thing, right? It's like you think about, like, this is wild. Again, if you're the state, this is your biggest battle. Your biggest hurdle is showing it's possible in the time period that fits with your theory. Like, you have to show that. If you can't show that, no juror is going to convict. I don't care who they are. And this is what you're offering, is this random dude. Can we find out what he looks like? Hold on. Wow. Running around the house, but there's no data, there's no video, there's no photos. At a faster speed and a slower speed. It's a simple experiment. I can't. What? No, he's from the Idaho. I can't even type correctly because I'm just so does he have a first name? I'm just blown away. Is this even real? Does he have Darren? Darren. Okay. This changes everything. This changes everything to me. Oh my God. Oh my God. Oh my God. I'm just trying to find this dude. There better not be more than one Darren Gilbertson. Okay, I have a thing. Let me control F myself. Okay, so he's one of these 3 people, but that doesn't really help. I just want to make it bigger. That's what she said. Oh my God. Okay, let's see if this will work. Jesus Christ, 50 bazillion tabs. Why? Tell me why. Oh, fucking hell, the Idaho Statesman's like, you have to buy the thing. No, not buying the thing. Where's the picture? Oh my God. Oh my God. Well, whatever. This is impossible, apparently. So, stupidness. Just trying to show you all a picture of what this dude looks like. Anyway, this random dude, Darren Gilbertson, is the dude that runs around and does a simple, you can't even call it an experiment. It's not an experiment, literally. But remember elementary school when you take science class and you have to learn what makes an experiment? None of those things were done. Wow. Right? Need some Z's, literally, right? At least film it. Well, and if they're going to say, okay, here's the thing. If they're going to try to say it's possible in 2 to 4 minutes, one of the reasons you need to film it is to prove that there's somebody there timing it while he's doing this, and that the timer is showing the amount of time, right? You see what I'm saying? If you, because you're saying between 2 to 4 minutes, you need to show that there's somebody there. You would need more than one camera angle, but you would need to show that there's somebody there timing it. Maybe having them with him, it's so that they're in the same room together, and then showing the timer. If you don't have that, what you have? You don't even have proof of anything, of any of it, even the time. It's crazy, crazy, crazy. Well, who cares what he looks like? Well, because I'm just thinking like, I mean, I'm what I'm picturing is what I picture with this name, Dr. or Detective Gilbertson. Clearly he's not that smart. I'm picturing like someone from like, again, like a parody, like, the Andy Griffith show. I've never watched that show. I don't know if that's the right thing. Like I'm picturing like an overweight dude with a big belly and a big silly hat. That's what I'm picturing doing this test. I don't know why I'm picturing him in socks. I don't know why I'm picturing him in socks, lumbering around and then doing this. And this is the silliness that results from it. That's just what I'm picturing. It was literally just for my own imagination, because I'm picturing the most silliest possible thing. And that's why I wanted to verify that. So it is a simple experiment consisting of timing, but there's not going to be any evidence. Okay. Detective Gilbertson moving through the house at a slower speed and a faster speed. His routes were described as well as his pauses. They're just described. That's it. They're described in writing. They're talking about it happening with nothing else. You've got to be kidding me. It was as well as his pauses to simulate the number of stab wounds each autopsy. It does not appear there are any. I mean, honestly, I bet there's not, because this is holy shit, guys. That's it. That's all the state is offering to prove one person can do it in 2 to 4 minutes. This is completely changed for me what in my mind is potential outcomes for this with any given juror. Right. So in other words, one time took 4 minutes and one time took 2 minutes, but not his speed. That even great point from Needs Some Z's, because that literally this entire thing is made up. Like, for example, if they need to prove it happened within a certain, so they're not even saying it's him moving slower and then him moving faster. They're just saying one time took 2 minutes, one time took 4 minutes. Oh dear. Oh dear. Oh dear. It does sound like an afterthought. I mean, 100%. You guys are being way more generous. I'm shocked. This is the craziest thing I've ever. Never mind. Forget the thing about the dude with the knife in the kitchen. I take it all back. I take it all back. This is the craziest thing I've ever read in a court filing. Literally, take it all back. The knife, it got worse. The knife, the dude with the kitchen and the knife, it got worse. It got worse. Things I thought I would never be reading. Again, not that the reading it is the crazy part, but that the fact that this happened. Really need some Z's? I don't see how. I just don't see how any juror, if you can't, the first thing a juror is going to ask themselves when they come in, they learn the very bare minimum details of this case. The first thing they're going to ask themselves is, how could one person do this in less than, I don't know, 40 minutes, right? Before you give them a time frame, that's what they're going to be wondering, right? Like it's just not ever a thing, not by knifing anyway. And like, anyway, with all the, but without even having other details, right? All they have to know is like knife, and like, even if you say under 40 minutes, it would be like, oh man, that seems crazy to believe. How that, And then it's like, oh, well, really, it's 2 to 4 minutes. The first thing that they're going to be saying is, how can a person do it? And they're going to be waiting for the state to show them how. Tell me how. That's what I think. They're going to attack the jury too. What do you mean? Attacking the jury? Oh, stack. Okay. That's great. That's funny. I'm glad Meg P didn't hear it. I see what you're saying. Right. I mean, I understand, but for me though, that's what I'm saying. For me, even given what we've seen recently with juries, this changes things. I expected them to at least have what I expected, right? I expected like a super experimental thing where they had like multiple Navy SEALs or whatever, right? Like this is what I pictured in my head. Going through, and I expected it to be filmed and them to have stopwatches, and they're showing like ninjas people, right? Like I'm expecting like ninja people with like ninja levels of like abilities of like to like that are also doing all kinds of things in order to make it happen. Like flying, like they can fly. This is what I pictured in my head is like people that basically it's like they may as well be able to fly, right? Or go through walls, like have invisibility powers to get through walls, like things like that in order to make it happen in the time period. And that anyone would see the video of this happening and be like, yeah, but that's not real life. That's what I pictured. I pictured them showing this video, a video to the jury of how they did this, and the jurors being like, yeah, but that's not real life. That's not real. Right? That's what I pictured. I think this has broken my brain, guys. It's the opposite. It's literally the opposite. I can't. They didn't even bother with the silly James Bond type of thing. That's what I pictured. Doom, or like Mission Impossible. Like I pictured that type of thing where it's like the jury would laugh at it because they're like, this is so not real life. These are like hired stunt ninjas or something. You guys, I'm terrible. I don't know anymore. And instead it's like literally somebody wrote it down. We did this thing. We did a simple experiment and they're writing it down. We did this experiment. We tried it. One time it took 2 minutes and another time it took 4 minutes. Signed Detective Gilbertson. What? Huh? And welcome. We have a new girlfriend, Ricky. Welcome. If you're new, you've come at a weird time because I'm literally doubled over in shock right now. So I hope I can still be coherent to a certain extent. Wow. The thing is, their only way around this would be to change the timeline. They're like, but they're married to that timeline, and like in other words, if they had a case here, I'm saying hypothetically, like let's just take another case or make up a case, right? Where again, you had 4 people that were stabbed to death, but the window of time was like 6 hours or 2 hours. You wouldn't the possibility of could someone accomplish this in that period of time wouldn't be at issue like it is here. But when you have 2 to 4 minutes with one person, I'm sorry, I will never get over this. I've lost my mind over this. Yeah, at least play with it. Well, that's what she said, right, P Fox? I feel like why am I thinking of Twiz right now, Heather? Heather, I'm sure you know. For some reason, why is it when I read this and then I'm like, at least play with it? That's what she said. And like all of a sudden, I'm like, Twiz comes to mind. I don't know why. Just automatic these days, you know? You know what I mean? Oh, okay. Wow. As for defendants, 403 concerns, they are baseless. Why? Because this is just an imaginary, like this is nothing. Is that why? The state represents that there was no structural changes to the house when Detective Gilbertson performed his experiments. I mean, I don't think he even performed any. This is where I'm at. There's no evidence that he even did anything, right? Literally, he's just saying it. So we have no proof that he even went to the house ever. Oh my God. The fact that it was vacated and that Detective Gilbertson was familiar with the home. So I guess he'd been there before for a different reason, but we don't know that he went, whatever, good point. Which would presumably allow him to conduct a faster timed run as fodder for cross-examination, not exclusion. The state further notes that the defendant stipulated the house being torn down. That's true. And after the report was disclosed. So in other words, what they're saying is, so it's possible he could have been there, because it would have been even funnier. The only thing that could have topped this is if he did this whole thing after the house was already torn down. And then he's like, yeah, I went to the house and did this whole thing. And it's like, well, the house was not there. That would have been the only way this could have gotten better. Thus, any concern or prejudice in this regard is his own doing. Ooh, that's rude. Finally, defendant cites no basis for jury confusion. Well, really? I mean, I think it's obvious. I'm confused. The basis is it's res ipsa loquitur. The thing speaks for itself. They're confused. I'm confused. We're all confused. Ah! Oh my God. Oh my God. Oh my God. Twas getting his beauty sleep. Right. It's 13, but no, it got smaller though. It got smaller. In the most recent one with the card, I think it went down to 7 minutes. I'm pretty sure it was 7 minutes. It got smaller. And then from there, they have to subtract like parking and then like getting out of the car. The reason they said 2 to 4 minutes is, trust me, they would have made that window bigger if they could have. Like if the window that looking at the state's timeline allowed for 6 minutes, they would have said 6 minutes. They said 2 to 4 minutes for a reason. But I remember thinking 7 minutes is what the new window was for the cars based on the stuff. Because remember, some of the timestamps were wrong. So I covered all that. And then I fixed the timestamps. I remember thinking it got down to 7 minutes. And I'm sure it's in the live stream where I'm like, wait, so it's even smaller now. I can already tell you what Denise would be doing. She'd be dying like I am. But yeah, I also I haven't seen Denise in a while either. Hopefully she's okay. I mean, she's probably just been busy with court. I mean, my thought is like, this is insane. And like, you're just going to just destroy him. Like you just make it, he's going to be made. This is going to be Trooper Paul. This might be worse than Trooper Paul, guys. When he goes on the stand to testify about this, they're going to obliterate him. It will be sad. It will be sad. It might be worse than Trooper Paul. I'm not even kidding. That's my interpretation of this, is worse than Trooper Paul. I'll just say. Oh, good. Okay. So you talked to Denise. That's good. Okay. Oh my God. Oh my God. I forgot how to read. That's why I'm just scrolling, guys. Just kidding. Gary Dawson. Let's move along. Gary Dawson. All right. So this is, okay, the degree of impairment of the victims. Right. His expert report attached to this disclosure finds that Madison would have been markedly intoxicated from the effects of alcohol. She would not have had the ability to mount a meaningful response to a sudden threat to her person. I mean, I'll just say there's no time for anybody to have a meaningful response. 2 to 4 minutes? I can't get over this. I'm just going to keep reading. Defendant seeks to strike his testimony on grounds that it is improper rebuttal. He contends that none of his experts have challenged her ability to fight back or otherwise contested her toxicology levels. The state responds that the opinion rebuts defense expert Brent Turvey, Mr. Turvey, opinion that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, the state argues that evidence Ms. Mogan was unable to effectively fight back supports the position that one assailant could have completed the homicides in a short time frame. It's the least of your worries at this point, state, because like Wow. I don't even know. It's like, oh, well, because the people couldn't fight back, it's definitely possible. I mean, but who cares because this? Who cares because this? Like, I can't. I'll never get over it. It doesn't, like, okay. Wow. Okay. Wow. I don't even. Rebuttal evidence is evidence which explains. I don't even care. Like, my brain is so broken right now. Okay, keep it. Mr. Turvey has opined in his report. Oh my God, that 2 assailants were involved in the homicide. Okay, so Mr. Turvey is for the defense here. 2 of 8 assailants were involved in the homicide, partially because he believes multiple weapons were used against Keeley. Again, interesting that it's just Keeley. Inferred in this opinion is that one person would not have had the time or ability to use multiple weapons in the time frame alleged when faced with 2 victims. One person would not have had the time or ability to use multiple weapons. When faced with 2 victims. If Miss Mogan was intoxicated to the point of being unable to fight back, however, it would be possible. I don't see how any of this is related to each other, and I just don't even know anymore. Heather, purple, great, purple. Why are we even giving them the time of day by addressing this? Like, I'm saying, like, if you're the defense, it's like this is the most stupidest thing ever I've ever seen. I can't even, y'all. I don't have words. I don't have words. I'm gonna try to keep reading if I can. Oof. However, Mr. Dawson's opinion is relevant. Whether it's relevant depends on Mr. Derby's testimony unfolds at trial. Consequently, Okay. Mallory, Tenzola, and Ulrich. Whatever. Okay. They're forensic detectives who were involved in the investigation. There are approximately 50 individual devices, electronic accounts, and digital data listed in the disclosures about which he will testify. And he will opine that he found no connection in that material linking defendant to the devices and data he analyzed. Jeffrey Tanzola is a special agent with the FBI. Hold on. I need to do this for my own sanity. You guys, my own sanity is at stake here. I will just say I need a mental health thing. Okay, hold on. Special agent with the FBI. The FBI! Who extracted, possessed, processed, and archived the contents of 7 identified digital devices belonging to the defendant. Oh, 7. He's disclosed to discuss the state's case in chief for all this shit. He did all the shit. Okay. Neil Ulrich is a forensic examiner and detective sergeant for the Post Falls Police Department who extracted the contents of computers. Great. I mean, this is all pretty standard stuff here, standard fare. Specific portions of the identified devices and data the experts will testify to. In response, the state clarifies that it not seeking to elicit opinions from these. Okay, it's going to say that they're fact witnesses, maybe, about their qualifications necessary to perform the extraction, so laying the foundation. That's standard. Okay, Rob Hill. Oh, right. Agent Hill. Right. The suspect vehicle. Agent Hill was disclosed to rebut opinions by defense expert Stephen Becker that it was not possible to ascertain from the surveillance videos whether a front license plate was missing from the vehicle. Okay. Agent Hill's rebuttal references the full summary of video depicting suspect vehicle 1, which has been disclosed to the defendant as a basis for his opinion that the vehicle did not have a front plate. He then lists the specific camera locations and timestamps he contends show a clear view of the missing front plate. Interesting. That'll be very interesting to see. Defendant contends that since Agent Hill has not offered an opinion to any videos other than those specific clips referenced, his testimony must be limited to those clips. However, Agent Hill's disclosed opinion is not restricted to the identified clips. It expressly based. There's a word missing here. Fucking hell. It expressly, I think it's missing the word states, based on the full summary of suspect vehicle 1, with the identified clips being the most clear. Wow, that's an idiotic thing here. If those clips are the most clear, isn't that what he's relying on then? You've got to be kidding. Whatever. I don't even care anymore. I'm over it. Dude, I've lost it with this whole thing with the freaking Mr. Detective Gilbertson with his socks. I don't know why. I'm just picturing him in socks. Socks only. This is crazy. Oh my God. Oh my God. Okay. Hang on. I just don't know. I need a thing.
You also told them that you thought you heard a wildcat, but maybe it was a person or something like that as well?
No, that's not what I said.
What did you say then?
I said when I went outside that there's a house cat that's gone wild, and he hangs around. He goes from hanging around the shop, goes from hanging around the house, different times. You might, and there'll be times you don't see him. And he had been around the house. And when I went outside, I believe that cat was over there.
And boy, you're busy bee on that phone right out of the gate at 9:02, right?
Am I a busy bee?
Yeah.
I am using my telephone.
So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees.
Yesterday I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendy made another new friend? Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know?
I know.
Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just come
I'm
up?
going. Sorry. Heather says, I met a new friend on a walk. Bitch, how old are you? I know. It is crazy. It's very crazy. It's very, very crazy. I know. Yeah, it's in Murdoch, it's the shape-shifting wildcat. It's just the best. It's like he says it's a wildcat, and then he thought it was a person. It's just the best. Y'all, okay. Whenever I talk about this theory that I'm like, I don't even know how to explain it because it makes no sense. We'll listen one more time. We'll move to proceed. This is it. This is the whole thing right here. This is it.
I'm trying to tell her that this is a big deal. Like if we go to the police on the second extortion, they're going to catch the second extortion, and when they catch them, they're going to turn, and the second extortion is going to turn in the first extortion. And then when you catch the first extortion, the police are going to come talk to us, and then when we tell them what happened, you're going to be in a lot of danger. There's no way I can talk to the police. So by catching the second, it's going to turn in the first. And that's exactly what I say in there.
You guys, just by the way, just fucking 5 all, am I right? Like, dude, I hate that. I hate her. Oh my God. Okay. Here's the thing. So I need to call Twiz and see if I can wake Twiz up. If I can't wake Twiz up, the question at hand is, do you guys want to watch the Nick Ballance testimony without, I feel like that's so mean though. I feel like he's going to want to be there. Y'all think of a backup. If we're not going to watch that, do you want to watch the Lori Vallow jurors, or do you want to do Karen Reed day 4? Four, oh my God, 5 all. Makes perfect sense. It makes perfect sense. It just totally makes perfect sense. You want to return to your original timeline. Wait, what is your original timeline? Day 4. So, well, I say day 4, but I have other things in store. I want to go back and review parts from that hearing from day 1, but also I want to take a look at the week as a whole, and has the state proven or the Commonwealth proven anything. I've got, and it's not easy, you guys, I've got the verdict forms and I've got all the jury instructions, and I want to break it down. It would be kind of a cerebral one. I think that would be right now, after my brain's broken from this shit, that would be my least choice that I would vote for probably right now. But anywho, that's what we will do for day 4. It'll be more like, if you're on that jury, where are you at the end of the week type thing. So I don't know. Let me try calling Twiz. Remember, guys, he told me that if I'm going to go live, I call him, it'll wake him up. This is what he has said. I'm calling him. I don't know if he has a voicemail set up or not. I don't remember. We'll see. I doubt it's going to wake him up because I've tried this before and it's not worked. It's ringing. I didn't leave a message. That's funny. Twiz is on Pacific time, but I'm not. I'm on East Coast. He doesn't have his voicemail set up. I should have said, leave a message for Twiz, with like the robot voice. That would be really funny. That'd be really funny. I need to tell him to do that next time I talk. And be like, Twiz, you need to set it up so that the robot says, leave a message for Twiz. So yeah. So much for that, right? He literally was like, yeah, you can call me and I'll wake up. Nope, not true. Oh my God, right? I know. So I don't know. Do you guys want to watch it anyway, though? I feel like my brain is so broken from this, though. You guys, it's just crazy. I don't even know. Right? I know. I feel like my brain feels like it's been in a blender. Blender brain. We could do some twin flaming because it's been a while. I think we need to do that. We need something. I need something to cleanse me. I need something to cleanse me. What does Bold need some Z's? Jodi Arias. Jodi Arias? A random Jodi Arias? Do we want to watch a random Jodi Arias like interrogation? I don't even know. Oh, trust me, if he thought we were doing Balance without him, he would be like pissed if he didn't wake up. Trust me. I mean, they didn't. It's going to have to be in your imagination, Heather. If they didn't film it, they didn't even take a fucking picture. They just wrote down that it happened. But that's why I'm saying, like, I feel bad. I don't want to, I really don't look. I just feel like it would be so sad. He's going to want to be there for that, guys. That's the thing. He's going to want to be there for that. So, I think we should hold off on Balance. I think we should hold off on Balance. Trust us on this. Wait, what am I saying? Trust us on? What now? What now? What am I saying that on? About Twiz? Yeah, no, for sure. I guarantee you guys that he would say, he would be like, I totally wish I could have woken up. Like, he would have wanted to wake up for this. Seriously. Like, he literally had told me before, if I'm going live about anything, to call him and wake him up. He literally said that for anything. Well, not even Kohberger specific, or not even phone specific, let alone Balance. Are you kidding? He would totally say that, but he's not waking up. Yeah. Right. Yes. No, seriously. I promise. Do you agree, Heather? In Twiz, there's also, we had that one time in Twiz We Trust, when we had Twiz was Twiz's church, and Twiz has all the things. Twiz's church and Twiz's Church of the Logic in Twiz We Trust. Oh God. Gotcha. Well, let me see. Okay, I need a cleansing thing. We're gonna do a cleansing thing, and then I think what we'll do is, maybe we'll just redirect over into the Lori Vallow juror thing, because that might be the answer to all of this. Hold on though. First things first. First things first. I'm the realist. Have fun mowing your lawn, toes. Drop this and let the whole world feel it. I'm still in the murder business. I can hold you down like I'm giving lessons in physics. Don't you want a bad bitch like this? Da-da-da-da-da. Okay. I'm looking for something. Anyone want to try to guess before I play this what it is? Oh dear. Remember, my brain is frozen and every way from what I just read with the dude in the house and the socks. Anybody want to guess what it is? I don't even know what that is. Boat and hose? Is that a thing? Sounds good though. Boat and hose. Boat and hose. I feel like I'm missing out. I don't know what that is. Anyone want to take another guess? It's not boats and hose. Okay, I'm not going to keep y'all waiting. We're going to watch this and then we're going to switch over. Okay.
Hi, everyone. I'm Shalia.
And I'm Jeff.
And we're talking about a really basic, very important twin flame question that everybody must have answered. And that
This is a new one. We've not watched this one, guys. This is a new one. I've not seen this. We've not watched this. We've not done twin flames in a while. We're going to watch this one video and then we're going to switch over. But what's his face? Why?
is, how do I know when my twin flame has been fully revealed to me?
How do I know the difference between my false twin flame and my true one? How do I know that this person in front of me is definitely my true twin flame and definitely not a false twin flame?
Yeah.
Because so many people will find someone and like,
I have to just say, for the record, they have yet to explain what a false twin flame is.
they're my twin flame, I just know it. Well, how do you really know for certain?
Because you might think you found your twin flame, and then they might say, no, it's actually this other person. And in order to be with that person, you have to change genders and pay us money for us telling you this. And that's what they do.
You know, outside of, being a powerful divine channel, and even then, divine channeling would not give to you the final result without logic to back it up, whether they're your true twin flame.
Logic.
Because
Logic. Like Twiz's Church of the Logic.
And even then, divine channeling would not give to you the final result without logic to back it up, whether they're your true twin flame or a false one. Because Shalia asked God, and if this person was her true twin flame, and she got yes, and her spiritual teacher got yes, and false twin flame.
Yeah, right. I mean, thankfully I didn't have to spend a lot of money to, but I did have to spend a lot of energy and upheaval, suffering.
Interesting. Unlike the people who are your followers, they have to spend a lot of money.
Being upset. Well, I mean, like, I didn't have to go to like psychics and is he my twin?
It's the same thing though.
But I did the same thing. I did the exact same thing. I found out because I was not going to enter.
Well, I just thought of something too, Heather. You know how it's like mansplaining and whatnot? It's like you have twinsplaining. It's when Jeff is doing his thing where he's like explaining to you how he's right. But I can't form sentences well anymore, guys. As you guys can see, I'm normally articulate. Not anymore. I'm broken. I'm broken from the document I just read. But for anyone who's just now getting here, we did the Kohberger docs and my brain is broken. And now we are finishing it off with some twin flames before we switch over to Lori Vallow, juror stuff. And I'm dead. I'm broken and I'm dead. There you go.
For that relationship, unless he was my twin. But I chose to fast track into my union.
Whoa.
And
fast track.
So it was absolutely essential that I enter that relationship under the illusion that he was my true twin flame, so that I could really heal the core blocks and barriers inside of myself to the love of my harmonious twin flame union.
This is a good one.
And there was no better way to do it than the way that I did it. But because I had a block that I wasn't going to do it unless it was my twin flame. Well, the only way for me to have
None of this is words. This is all just complete word salad. Isn't it great? I just love it. And look at the way he just smiles creepily is great. I wish Meg was here. Meg would want to see this. Meg.
evil,
Same thing.
I mean,
suffering,
not just Meg. A lot of people.
upset. Well, I mean, like I didn't have to go to like psychics and is he
What?
my
I mean, it's the
friend?
same thing though.
But I did the
Oh my
same
God.
thing. You know, I did the
Same thing.
exact same thing. I found out
Mhm.
because I was not going to enter that relationship unless he was my twin.
Mhm.
But I chose to fast track into my union.
Fast
and so it was absolutely essential that I enter that relationship under the illusion that he was my true twin flame so that I could really heal the core blocks and barriers inside of myself to the love of my harmonious twin flame union. And there was no better way to do it than the way that I did it. But because I had a block that I wasn't going to do it unless it was my twin flame, well, the only way for me to have my true dream and desire honored was for me to believe that he was my twin flame, and even getting that information channeled. It wasn't so much that I was being lied to, it was that I was lying to myself because I didn't want to believe
Craziness.
otherwise.
Holy shit.
And I wasn't open to it, and I was not going to explore that essential relationship unless he was my twin. But
Oh my God.
you know, I called in the fast track,
Mm.
like many of you are calling in the fast track to your union, because
What
the
fuck?
sooner you're in your union, well, frankly, I think the better. That was my
I think
belief.
everyone thinks that.
I think everyone thinks that, right?
Yeah.
But I mean, I had a choice.
Oh my
I could
God,
take
his
the
face
slow
is
track, which would have been a lot less bumpy, a lot less upheaval. But
Take the fast track, not the slow track.
I'm just a really daring person, and I want what I want, and I'm just gonna do it. So my point, so what we're saying is that yes, you can get this information channeled to you if you think Jane or Tommy is your twin flame, but at the same time,
Jane or Tommy?
everyone goes through this, and this is what we call the revealing process.
Mhm.
And this
Oh.
is really, really essential to your twin flame journey, because this is about really knowing who you are and really getting to know the person who you think is your twin flame, because we're here to transcend that old relationship blueprint. And in order to do that, we really have to get clear on our values, our dreams, our desires, and really call in the 100% compatibility of our perfect partner, which our perfect partner is our twin flame.
Of course.
And so with Jeff, I mean, it took me a little over 4 months
It's the call.
to
Yes.
have him fully revealed to me
Oh, yeah.
as my true twin flame. And for him, it was almost 9 months to a year
Abby,
for him to fully realize.
what better way to start your day than this right here, guys? Welcome, Abby. Welcome, everyone.
Yes, this
Getting
is
here.
my true twin flame.
Yeah.
Because it wasn't just enough for it to be channeled. We had to really test the love.
By the way, everyone, I'm so glad. Everyone, congratulate Black Widow on her new place. I'm so glad that you're that it's great. I'm so happy for you. Is he okay? Definitely not. Also, he thinks he's Jesus.
And the full depth and extent of our twin flame union to know what it is.
And for me, it was about pushing on all those places to find out whether they were real for all the things that I valued.
Yeah.
So if she did not value what I valued, she clearly was not for me.
Mm-hmm.
So for me, the revealing process required that I test every value, not just we talk about it, but truly test and have
You're missing the crazy music in this one.
all of those values truly revealed.
Yeah.
And God provided all the situations for that to happen for us.
Yeah, like I remember very early on, having the guts to ask him, like, look, do you want to be a father? Because if you don't, this will never work out.
Oh Lord. Oh, that's a whole thing.
Because I must have at least one child. I must be a mother in this
Oh,
life.
dear.
Yeah.
I have that desire. And if that's not what you desire, then you're not my twin flame.
Easy, right? Start with the big ones and then move forward.
Yeah, exactly. We started with the big ones, you know.
The truth is, anyone can say, "Oh yeah, I want to be a father," just for whatever reason, to move the relationship forward for some sort of secondary benefit.
But what really helped reveal Jeff to me was when he was asked to babysit his friend's two young boys. And I got to see Jeff around children, and I got to imagine, okay, so,
Oh my God.
you know, I'm giving this opportunity to see what kind of father would he be. And I was really impressed. I'm like, yeah, he will make a really good father.
I have to show you guys this first, because some of you guys aren't as familiar, and if you are familiar, this is hilarious. So this is the same dude, okay? The same dude. This is the Twin Flames call. This is the same dude. This is this dude later on and he's going to look different, so I'm mentioning it, talking about his tiny waterfall.
I gotta show you that waterfall though. Oh, there's a little waterfall coming out of the spa.
Wait. He's calling that a waterfall? Guys, what do you think that says about his you-know-what size?
And the grounds have been a fixture in their online videos.
I gotta show you that waterfall though. Oh, there's a little waterfall coming out of the spa.
I'm dead. Goodbye. Oh my God, I'm dead. I'm dead, you guys. I'm dead. This wins. That is the waterfall. What? I don't.
For years, this house and the grounds have been a fixture in their online videos.
I gotta show you that waterfall though. Oh, there's a little waterfall coming out of the spa.
That speaks volumes though, doesn't it, about him? Holy shit. He calls that a waterfall? Oh dear.
I get this in my pool, my slide.
Oh my God.
You know, my little hot tub, and
Is he going to say the waterfall? Is it
got a little waterfall. We haven't really.
Oh my God. Hold on. I was saying that as a joke because this is a different video and different outfit and all that. No way.
But it's getting there.
I'm dying.
And take some time to get a house the way you like it. This is my pool, my slide, you know, my little hot tub, and we've got a little waterfall. We haven't really furnished it yet, but we're going to make it real nice. This is my house.
Oh my God.
This is the back of it.
Waterfall. You've got to be
It's a pretty sweet spot.
Any of you guys that are members, feel free to throw some Jeff emojis in the chat. Oh, I know. It's so good. There's just so much, the Twin Flames. Okay.
We really align up in many respects parentally. We can't.
We're going to go to this one, writing a love
So this is a really important and core example of how your twin flame becomes revealed to you. It's a process, and yes, it does take time because all these areas of your life that you value.
What about the fast track, though? She went on and on about the fast track. I feel like, wait, I was believing them before, but now I think this is bullshit. Just kidding. Dude.
You will get tested. And that's why we mentioned in our, I think it's Dreams Coming True course, Twin Flames Dreams Coming True Lesson 1. We talk very specifically about writing a love list. That's literally one of the first things you need to do when you truly embrace this journey of getting into your permanent harmonious twin flame union. Do the love list, meaning write down all the qualities that you desire in your partner. And I'm not talking about blonde hair, blue eyes.
Yeah.
No. We're talking about the inner values. Yes, you know, maybe you desire a man who values beauty, who values his health, who values feeling good. Maybe those kind of things, right? Like good.
Oh my God. So that's the same thing, but less shallow. Like instead of writing down how you want them to look, be like somebody who values how he looks, somebody who works out all the time. Oh my God. That's so funny. Wow.
To the inner stuff. A man that's supportive, or woman, because I'm talking from the female perspective, right? So all that stuff, you need to get very clear, and you need to also look at your previous partners and look at what you don't like about them, what really the shit that broke you up, and write down the contrast
Well,
of
don't
that.
do anything that they say, by the way, in case anyone's confused. Like, everything they say is dumb, and don't ever do it.
So, okay, if you dated a man who was incredibly lazy, then on your love
And
list,
that bothers you.
and that bothers you, that upsets you, that's not
think
something
she's okay
you
with
don't
lazy.
value laziness,
Mhm.
then you would value a man who is not lazy, who is hardworking, or whatever that means to you, that has ambition. And I'm really excited now. So that's what we really, so do the love list. Get really clear on who your man is. I did a love list. Jeff did a love list. And like a couple months after online dating, I brought the love list to our Skype call, and I was like, I want to show you this. And I'm just curious. I hope you don't mind. And I read all of it, and I was like, oh my gosh, without it just blew me away, guys, because I'm looking at Jeff, I'm reading my list, and I'm like, damn, this is you. This is you in the areas that I thought was practically impossible to have, let alone ask. And he's
a total package: psycho, narcissist, cult leader, thinks he's Jesus, potentially also a child essayer, slave owner, all the things.
He was 90% my love list. The 10% was stuff he was still growing into, which is allowed. Okay. But it's just being aware of everything on your love list and realizing that, oh my gosh, you could quite possibly be my twin flame, because you all this.
Oh my God.
So another important thing to do is to equip yourself with the right resources. Twin flames are a very new concept. Anyone with a camera can get out there.
They just made it up.
And talk about it.
Right.
Anyone can claim authority. Anyone can put up a pretty web page or shoot pretty videos and claim authority over this topic. First of all, who has it for real? Listen with your heart. What is that person's agenda? Listen with your heart. What is their real agenda? They're communicating it in everything they do.
Mm-hmm.
Does that agenda serve you too? And is the information good? Is it real? Does it provide real results?
Yeah.
And make your own assessment.
You have to apply what they're saying, and apply what we're saying, and see if it's true. If you get results from it. If you're not getting results from not applying what we're saying or what they're saying, well, I think it's safe to say, it's time to move on.
And that's why
find the real thing.
People and clients keep coming back to us again and again and again and again, because they get results with our work. And
Wait, that doesn't make any sense. If they got the results, though, why wouldn't they leave? Like imagine that too, right? How do they get the people to stay? So people, they quote unquote find their twin flame, they pair them up and make them change genders. But anyway, but then why don't they just, that's what they wanted, then they could just leave, right? But no, they can't, because they're in a cult. So they have to stay there forever. Even though, it's not like they're not trying to have you have more than one twin flame. They want you to have your twin flame. Although, having said that, see, now I'm rethinking it, because then they started doing this thing where you break up with your twin flame and then they can repair you again. And then that's another thing, right? Oh, that wasn't your real twin flame. That was your false twin flame. Now we're going to find your real one. That's probably what, anyway, this is it.
you can too if you apply it. So check out the box below for the resources that we offer to bring you into permanent harmonious union with your twin flame, and deepen that relationship.
Wow.
Like, share, and subscribe to our videos for more good twin flame stuff. And thank you again for joining us.
Yeah, y'all, they're smiling now, but I wonder if they're going to be smiling when they're in federal prison, because they're being investigated by the feds. Go get them, people. Go get them. Take them and take them down. Oh my God. Oh my God. Okay. So now this should redirect you guys into the next stream, and we're going to take a look at what the jurors said speaking out after Lori Vallow's verdict. And I've got some other stuff there as well we will take a look at. And so thanks for watching. Love y'all. And I'll see you guys here in just a second.